Still under oath.
Thank you, Chair. President, I just want to recap what we established yesterday. We established yesterday that through no fault of yours, you were not provided with everything that the record contained, right?
Yes.
We established that in coming to most of your conclusions, or some of them, if not all, you had not read the affidavit of the respondent, right?
That's correct.
We also established yesterday that the paper that you quote, am I correct that you were not entirely familiar with it?
I haven't read the paper in a long time.
Yes, I'm saying yesterday, yeah, you were not entirely familiar with its conclusion.
My point in using a reference, as I explained to you, was simply to talk about the assumptions. What the paper is investigating and showing don't actually exist in the way people live on a day-to-day basis. Sure. What the paper was saying was looking at the discrepancy between what is popularly assumed and what is lived. This is what the paper is about. It's talking to how people live beyond and outside popular assumptions. The assumptions that I refer to as guiding.
No, actually it doesn't. It's the topic that misled you. The topic in inverted commas makes the assumption, but the paper critiques the assumption.
Yes, and that is what I am critiquing too, that the assumptions are very problematic.
All right. Ordinarily, when an expert says she has not had sight of the full record, it would stop. But I think we would learn a little more from you if we just pursue a few assumptions that you make. Am I correct that one of the assumptions you make in reaching your conclusion is this that you say the complainant in these circumstances is sort of childlike in her approach? In fact, I think you used the phrase childlike.
Yes, if we look in terms of a kind of structuring of relationships,
Yes.
father, and if you call someone father, that implies you are the child. Therefore childlike, not an actual child.
In fact, the chairperson asked you this question. It's for that reason. Is it for that reason that where she says something, you attempt to interpret it differently so that we must trust you, not her word?
In relation to the father relationship?
Just generally, you keep saying she said this, but she meant this. I'm saying one of your assumptions is that we should not, and I think you explained this, we should not believe at face value what she says. We must believe your interpretation of what she says.
And I explained why I came to that conclusion.
I know. We'll get there, Ms. Verten. Don't psychoanalyze me. You don't know where I'm going. I'm saying you made the choice that even where her words say something else, we in this tribunal must believe how you interpret it.
I'm offering an opinion, which is up to the tribunal to accept or reject.
Yes, that's all I'm saying is that your opinion is that we must believe you about what she means.
As I said, it's up to the tribunal to decide whether they do believe.
Okay.
I am asked to offer an opinion, which you accept or reject.
It's fine, man. It's fine. Take this further.
Sorry, just interrupt you. She sounds like her voice means is she being properly correct? we're having that assurance that the evidence is properly recorded. Somebody has to raise their hand to say, I'm looking. I need an assurance that this recording is accurate and proper. There's an English saying which says, I'm sure it dates back to the day when we were still students and using ink and a fountain pen. The teachers would tell us, please write whatever you've got, whatever has to be written. Because even after some time, if the ink fades, there's an English expression which says, the faintest ink is better than the strongest memory. So we are not going to try and rely on our memory. We are going to rely on the recording. And that is why it has got to be done properly. And once you feel that it's not being done properly, just stop us. Thank you. There being no indication to the contrary, we assume that the recording is clear and accurate. Thank you. You may proceed, Mrs. Vattel.
All right. The point I was making, Ms. Verton, was that, yes, it's for the tribunal to decide, but you are the expert giving an opinion. And all I'm saying to you is that the assumption in your opinion is that faced with words and phrases and statements from the complainant, you offer, and many times yesterday, you offered a different interpretation of what she said. Sometimes the opposite, you call it deferring, even when she's saying something straightforward from her mouth.
The particular example you refer to, deferring, is one, at the time she says, will do. So if you take that at face value, she's going to go and take a photograph.
Yeah.
She doesn't do that. He asks her again and persists to ask for a photograph which is not sent. One way that can be interpreted is that when she says, will do, or I'm going to do something and I'm not doing it, it's one of those situations where you tell people in order to placate them, I'm going to do it, but you don't. So one must look at the words and the action. As I said, the first time this happens, you take what people say at face value. But again, if you look at patterns, then you see there is a pattern here of saying one thing and doing another thing.
Did you interview the complainant?
No, I was not asked to.
No, I'm not asking you that, ma'am. I'm asking, just say yes or no. You don't have to be sarcastic with me. I'm saying, did you interview the complainant?
Chair, I'm so sorry. I'm not the evidence leader, but can I please ask that the panel instructs Advocate Sikakane not to say things like that the witness is psychoanalyzing him when she's clearly not, or that she's being sarcastic when she's clearly not. It's true that she's not answering yes or no, but I don't think that helps these proceedings at all. Thank you.
Mr. Sikakane. Mr. Sikakane, you said what she says.
So, Ms. Verton, all I'm saying to you is that because you did not interview her, don't you agree with me that the possibility that your interpretation and analysis of her intention could be wrong?
One can't rule that out.
In fact, you make you do explain, and I think it's an important, and it's covered in many of your papers, which are good. You do explain that when people face at workplace these particular situations of hierarchies and someone powerful, and they can get confused about what they do or what they say, right? But let me ask you a rather personal question. You work at VETS, don't you?
I'm a research associate. I'm not an employee.
Yes. But knowing you, wherever you've worked, I think, and tell me if I'm wrong, knowing you, you would tell a person who makes advances towards you where to get off, wouldn't you? Who's in authority? You would.
I would do my best, but I must say when I was younger, there were times where I was quite taken aback and didn't always know how to respond.
It's fine. I'm saying now you would. I'm putting it to you that I think knowing you, if any person made advances at you, you would tell them off.
I would.
Right. You've got to explain a little bit for me. Would you do that because you are older, because you have better moral rectitude, because you have a better courage of your conviction than the complainant? You seem to suggest that she wouldn't, she doesn't mean what she says. Is there any reason why you believe, either because of age, race, or status, that she is not like you? She wouldn't speak her mind.
As a general principle, I don't go around assuming that other people are exactly like me.
Perfect.
That is a mistake.
It's fine. But I'm saying, why would you assume this one you did not interview? It doesn't have to be like you. You're not the only one with a better moral rectitude. I'm saying, why don't you assume that she has the courage of her convictions?
My evidence is that at times she certainly does have that. She tells him no a couple of times. So she certainly does have that. What my evidence says is that her response is at times ambiguous. Sometimes she's able to say particular things, at other times she isn't. That is consistent with some of the experience I've had with other complainants. I don't try to read myself into a situation.
No, I agree.
Or assume that what I should do is what everybody else should do.
Yeah, all I'm saying too is that you cannot dispute the fact that actually she is just like you. She may just be like you, strong moral rectitude, courage of her convictions, and is not scared actually of authority. Would you be surprised if you found that out?
I wouldn't be. I mean, I think it takes enormous courage to actually come here.
Yes.
And it takes, so that is to be admired. And sometimes people might not have that initially. It may come to them precisely through difficult situations.
I fully agree with you. So it may not be entirely accurate that she's this childlike person who cannot speak her mind.
I think when I use the term childlike, it's not necessarily about speaking with mind. It's about position.
It's fine.
Respect. Who do you defer to? Who do you respect? What is the appropriate way in which you approach somebody? It's not necessarily lacking courage. It's just that I think as we go through life, we learn that you don't use F words to your CEO. That would not be considered appropriate. So it's more like if we fulfill or live or occupy certain roles in life, that's often how we are supposed to engage with each other. And I'll give an example now. Your role is that of the defense attorney. Mine is that of a witness. And so you expect me to answer in particular ways in terms of that role as Advocate Budlander fulfills her role. So there are ways in which we can and can't respond to each other. As when you say to me, I mustn't be sarcastic, you're telling me I'm not fulfilling the role of witness. That's my point, is that there are roles which kind of shape how that we are expected to behave.
You put me in my place there. Right. So, all I'm saying to you is that you will agree with me that without having spoken to her, knowing her intentions, the tribunal must take the things you say about her, not as wrong, but as generalizations. They are not specific to her. You don't know her intentions when she said something.
What I'm offering the tribunal, and again, as I said, it's for them to take it or leave it, is what I read from this, how it can be interpreted. I'm not offering holy writ here. I'm saying this is how it can be interpreted on the basis of my experience with other complainants.
And that we did establish with you yesterday that because you did not look at her cross-examination where her assumptions, her statements were tested and where she made certain concessions, you have no access to the concessions she made.
I did look at them yesterday.
And we'll get there. I'm talking about when you provided us with your report. I knew you were going to say you had a look last night. All I'm saying to you is that when you provided this report and you gave evidence, not when I reminded you that you didn't look at it, when you gave this report and gave your evidence in chief, you had not had a look at her concessions and how and when her testimony was tested.
Actually, I stated up front that I hadn't gone through the cross-examination in great detail.
Yes.
Sorry, Mr. Skakani, I think I'm going to go back to something which is important here. To the previous question you asked. Mr. Skakani said to the following fact: because you had not interviewed her as a person, the tribunal should then look at what you said as generalized, let's say generalized opinion, because you never interviewed her, you can't zoom onto her. Well, what you said were general remarks in general terms and not specific to her. I think that is the essence of the question.
My comments are based on what I read here and how I understand or see what she is saying. From what I'd also looked at in terms of the her evidence in chief as well. That is how it was understood, and what was done was, what I was trying to do was contextualize her evidence as well in terms of what I am familiar with in terms of other complainants. Hence the broader explanatory framework of this is how sexual harassment is understood, this is how complainants can be understood, and then in light of that general contextual background, this is how one can read what she is saying or not saying here, and how she is responding.
I interrupted you, Mr. Skakani. So.
Well, I'll go back there, but the point I was making is not that you're wrong, and all we're saying is that those are generalizations, not incorrect ones. They are generalizations about cases of sexual harassment. But of course, if we must make a choice between your generalizations and her words and what she says, both in those communications and even here at the tribunal, we've got to accept that yours are generalizations, may or may not apply to her.
She is ultimately the authority on her experience, and her what she says is what must ultimately be what you take. This is a way to try and understand what she's saying.
And I'm saying this because you must be aware, as sympathetic as we should be, but you must be aware this is a 42-year-old woman, right? Whose words must be respected, don't you agree?
Like any other woman's.
Yeah. Whose intelligence must be respected.
Correct.
This is someone who knows what she says and thinks what she says. You agree with me?
Correct.
And there is no reason it would be patronizing for all of us in the room, including you, to assume that she's a child whose actions and words must be interpreted by some either superior male or superior other woman. We must believe what she says. Don't you agree with me?
No, because I think you're misinterpreting what I mean but when I say childlike. And I repeat again that I'm talking about a position in relation to the judge. I'm not talking about somebody who's actually a child, should be thought of as a child. It's more like positions of authority.
Yes, no.
It's not about people's mental capacity. It's not about their abilities. It's about the degree of respect or deference you are expected to show somebody when you are positioned in a particular role. It's not that that person is a child and you treat them as a child.
If you found out, and I'm not going to make it specific, if you found out that a complainant, not the complainant, a complainant has a history of belligerence towards a senior person, would you still hold the same view?
It would depend. You'd want to know about that history. You'd want to know how it unfolded. You would have to take a whole lot of factors into account.
What would you take into effect? If you say someone fears authority, and I demonstrate to you that that complainant actually does not fear authority by action, does not, would it change how you look at them? Would it change how your generalized opinion that they fear authority, maybe that's why they don't say certain things?
It would depend on the circumstances. So if it's in a workplace setting and you are contesting over workplace issues, that's one thing. It's a different thing if you are contesting, where you have guidances around grievance and other kinds of procedures. And I mean, a situation, let's use the courtroom situation, where that person may or may not be your line manager, you can contest with them. Somebody who has a higher authority than, say, your immediate line manager, for whom you might have greater respect, that may be different. I mean, the way you respond to people can also depend on the degree of respect you have for them and the degree of liking you may have for someone. You can be it's possible that you can look at people as being complex. You can both admire them and dislike what they do. And that feeling perhaps of admiration or respect can come into conflict with the feelings of anger.
I'm going to repeat this question because I see what you're doing. I'm saying to you, when you make an assumption that someone fears authority and therefore that's why you should not believe them when they say yes, you not believe them when they say this. When I give you an example that a particular complainant has exhibited a propensity different from your assumption, which is actually does not fear authority, would it impact on your assumptions about them specifically? I know your generalized view, but I'm saying, would it not affect your analysis?
I would certainly want to look at it.
Would it impact your analysis at all?
It would depend on on the information.
If the information is that actually this person, this complainant has actually even physically confronted a line manager, a supervisor, what would you do? Would you still interpret them as, I'm giving you a practical example.
I would want to know more about the circumstances because what it might indicate is somebody who has difficulty with conflict and conflict resolution. Somebody who veers between, you can have somebody who is very aggressive under some circumstances. You have people who are passive aggressive. People can shift between different things. So I would want to have a look at those details to see how do they add up.
All right, I'll leave this question. I think I'm not going to get the answer you don't like. Let me move to the paper that we were dealing with yesterday, just for one point, for its conclusion. Let me first ask, you are before this tribunal as an expert in what? Sexual harassment? Power in general as a notion, as an academic notion? Or psychology or emojis?
Definitely not psychology, definitely not emojis. My expertise is in gender-based violence. So I'm assuming that's why the tribunal thought I could add to a view on sexual harassment. And if you look at most of the theorization on gender-based violence, it is rooted in an understanding of power. So the two are related. So one underpins the other.
It's fine. So where we find you saying an emoji means deferring, but an emoji specialist says it's flirtatious, we should believe not you, but the expert on emojis.
Yes.
All right. Because you touch on the subject of power, I want to take you to this paper, just one conclusion, and then we'll move to the theory of power. You will see that the paper you referred to by Graham and Papudi, right at the end, one of the things they say, and it relates to the subject you ventured into, and my learned friend started there, is power relations. And the conclusion they make is that although they were dealing with young people in depressed economic environments, but they say the findings presented in this article demonstrate that while dominant, patriarchal, essentialist notions of masculinity and femininity strongly shape the gender identities of the young men and women in these studies, and in turn their sexuality, their negotiation of gender identity and sexuality is also contested and fluid, right? And I mean, what this does is that it tells us, and I think you will agree with me, that it tells us that power relations are not static. Would you agree with me? That they are fluid. You don't have to agree. It's a notion by Farquhar. You may believe in the other theorists on power, that power is everywhere. It means it moves. Would you think in relational power relations that's the case as well?
My PhD does deal with Foucault, where I've looked a great deal at his notions of power as diffuse and its multiple forms. Yes. So I think when we look at this, and this is what I was trying to explain, we should not be thinking of power in blunt and one-dimensional terms.
Absolutely.
That we must think about it as multidimensional, and you may have heard me saying it is dynamic. It is built on the interactions between each other. Yes. Foucault's other point is that there is discourse, which shapes us into particular ways and means it makes it difficult to break out of discourse. So the examples I am using when I speak about things like assumptions about male and female sexuality, those are discourses. Yeah. They are powerful discourses that trap us, in which people read us through those discourses. They take on a certain solidity even though they don't necessarily have it. So that is certainly the way I would be thinking about power. That is why I do distinguish between formal and informal power, because you cannot ignore that there is formal power. There is informal power. There is an acknowledgement that people find ways to resist and to exercise agency within their particular roles, or however they may be. But yes, it is important to take a complex notion of power that recognizes how it shifts and does alter, but that you also, and this is an area where Foucault has been critiqued, is that sometimes he speaks about power in such diffuse terms, you can't actually realize where its center is and how you deal with it. And one must still explain things like workplace jobs and rules and formality, the way power is working in this room at multiple levels. So yes, there are multiple ways to look at power. That's my very long way to say it.
Once again, we agree. I was just saying to you, because human relations and power, in fact, we'll deal with that, because that's as you say, I'm not an expert in Foucault and power. I just thought it's something you could enlighten us, because I think, and you've done that. All I was saying to you is that you would agree with me that when you're looking at engagement between two people, it's a mistake to think that power remains in the same place as formally established in the relations between two people. It can shift.
That's my point about it being dynamic.
Yeah. So even between someone that you think they are in a childlike father relationship, and I'm not mocking the point, because it's an important point you make, but I'm saying even in those relations, power can shift between two people, someone who's known to be powerful, dealing with someone who's formally less powerful, but in their interaction, power can shift from the formally powerful to the formally powerless.
That can happen, and I think my evidence was that you can see things shifting between them, and you can see a change in the nature of the interactions, and you can see, particularly after a particular date, that they have changed. So quite clearly, things have altered. And the fact that somebody makes a complaint shows that things are shifting.
Yes. And you're so right that can shift even during a conversation. It's or during, let's call it a relationship, right? And it can happen during courting, flirting. In any form of relationship, that can happen. Friendship, romance, marriage.
Yeah, relationships are dynamic.
Yes. Well, you also ventured into advice on something that I'm definitely sure you're not an expert on. You said you would have advised, or you would, if the JP was interested in the complainant, he should have approached it differently. You remember that? Is this an area you're an expert in? The area of courting in his culture or their culture? Is it something we should take your word on, that of suggesting to a closer man how he should engage in courting? Is it something that we should take as your expertise?
No, and I'm not offering it to him. I'm not offering him advice in terms of his love life. My commentary was based on policy work in relation to sexual harassment and workplace relations. That was the context in which the advice was offered, and it has been, in some of the work that I've done on sexual harassment, we put that into policy. So this was in the context of talking about workplace relations, because you have, as I pointed out, a blurring going on here.
You even said that he must at least seek permission from his wife?
Well, I was saying, in the context of a workplace, it would be difficult if we're saying it needs to be regulated and you need to put forward that you are interested in somebody. That's going to be, in his situation, somewhat difficult if he is already married. I'm acknowledging that might be somewhat difficult if you put that into a policy where you ask, which has been done, where you regulate relationships.
Yeah, all I'm saying to you is that you are venturing into advising somebody about something that is well embedded in particular regions, particular cultures, particular languages. And it's not your area.
My advice was in relation to how do you manage relations in the workplace.
Yeah, but you were also advising, you were talking about what he should have done if he's interested in a woman.
That is in relation to the workplace.
Yes, but I'm saying you were not talking about work. You were talking about how he should approach a woman. It doesn't matter where.
No, my comments were restricted to the workplace. It's
So
not appropriate for me to be mentioning what he should be doing outside the workplace. But we are talking about a workplace scenario, and what is recommended you ought to be thinking about or considering within a workplace context.
I agree with you. But all I'm saying to you is that you agreed with me yesterday, and I told you that you were the expert of last resort, because what was needed was someone who has the cultural and linguistic nuances to understand a couple of things. One, the conversation between two people of a particular culture. Secondly, assumptions about how courting, let's call it dating how it happens in particular cultures. And you agreed with me that cultural and linguistic nuances are important in analyzing what's appropriate and what's not.
That is correct, but again, we're talking about what is appropriate in the workplace.
Yes, no, I'm with you. I'm saying whether we're going to get there, whether dating someone who you work with or someone you don't work with, all I'm saying to you is that we established that culturally and linguistically, things vary from, how people do things can be influenced by the dominant culture and linguistic nuances in that culture. You agree with me?
That I agree with you, but I don't take your previous point, which I think you're trying to connect, that means that in the workplace, that alters relations, allows relations to happen in a particular place. There are different rules that govern a workplace. That is my point.
That's fine. What advice would you give the complainant? as you gave the respondent in the same situation?
When faced with a situation like
Faced
this?
with someone who's flirting?
Well, one would sit and talk to her and ask with her, what does she feel comfortable with, what does she not feel uncomfortable with? Is she able to approach him? What might be difficult about approaching him?
Okay.
If these and these are the difficulties, what are the ways in which we might get around those difficulties? How else could this be addressed? Could somebody intervene on her behalf and go and speak to him? If she's not yet at a point where she is ready to lay a grievance or go to human resources or whatever it is, what else can she do? In some situations where somebody doesn't feel they're able to do anything, you will advise them to keep a diary of interactions so that they know what is going on and that they don't forget what is going on, because if this should ever go to trial, they would need to know what they would need to be able to know and what to remember. You would look at ways in which you could try to assist them to feel more assertive, to find out what kind of support they have. If they feel they cannot do anything about it, then to ask, do you have anyone who can support you, who can help you, assist you? How can we help you? Would counseling support you in order to be able to feel more confident? So you would look at what is it that the person can manage? What is it that you can realistically ask them to do? Somebody who is in a very difficult workplace situation, you just have to take into account what is that person capable of and explore with them what their options are.
Am I wrong, Ms. Vetten, that, and I'm not wrong, am I wrong to assume that in your testimony, and as it is in your papers, correctly so, you are more sympathetic towards a complainant, not a complainant?
That is my background.
Yes.
I have been a counsellor.
Okay. Yeah, no,
and I'm there to assist. That is the basis
the
of it.
Complainants.
Mm.
Yeah, okay. Would you think that kind of stance, I told you where I wouldn't be a good expert yesterday, because I wouldn't be objective. Do you think that stance makes you objective or not objective?
Well, as I'm sure you're familiar, there is a great deal of contestation around what the word objective means.
No, yeah, I know.
But
you can lecture me about it.
No, I'll spare you that.
Okay.
So I think my experience is with complainants. The reasons why people have asked me to be an expert in other situations or to come and give testimony is for the simple reason that gendered forms of violence have a long history, and excuse me if I'm going, I'm sorry if I'm lecturing you.
No, it's fine. No, it's fine.
They have a long history of having been overlooked, having been neglected, having been downplayed, having been dismissed. Our Constitution has tried to do that. We have constitutional court cases that try to recognize this. So one of the ideas behind expert testimony is that in a context where women's experiences have been routinely dismissed and where they have not been recognized and where the law has not been able to accommodate them and where they may be unfamiliar, sometimes you may need somebody who has that kind of particular background or knowledge to come and say, within the context of what we know, this is how somebody may behave. It's to give context. Because quite often what can happen is that people may think women's responses are simply bizarre, or they don't understand them, they don't make sense. So the idea is to have somebody who can say, well, based on the background, based on the experience, based on what we think about power relations, this is how it can be understood.
I agree with you, but that makes you, and which you are, by the way, and the good one, is you are an advocate for women's issues, which is correct. In fact, you are an advocate. No one does it like you do in this country for 30 years. You are an advocate for complainants of sexual harassment. That I accept. But all I'm saying is that let me put this danger to you, because I put it to myself, that if I were to testify in matters where I must choose between African people and others, I would refuse because I have a particular affinity. And I would refuse because I would not resist the temptation of not being objective. And all I'm saying to you is that, well, with that background, which is not a bad background, do you agree with me that a person like you and me who have strong views about a particular side of things can actually sacrifice objectivity and present views that are filled with their own feelings and idiosyncrasies?
I would hope not, because as I said to you earlier, I sit on panels, and I am required to adjudicate on matters. And there have been cases where I have not been, where looking at the evidence, you cannot find somebody guilty of sexual harassment.
Yeah.
There have also been occasions where I've been asked to comment on someone's behavior, and I've had to say, there is no sexual harassment.
Yes.
So I have an insight and experience, but that doesn't mean I automatically come to something assuming.
Yeah, no, I'm not making that accusation against you. I'm just saying that where objectivity is required, and I'll go to the things that I think you omitted yesterday, and I will tell you why I think you omitted them, and you can differ with me. First of all, if we move to one of the assumptions you made yesterday when I conclude this thing about culture, is that you said something very powerful, that a yes is not a yes in perpetuity. Am I summarizing your view? Is a no in perpetuity?
No, not necessarily. However, if you look at the law does say that it is no until such time. It is no until somebody says something different, but one must bear in mind where that is not an invitation. This is where the line becomes one you have to think about very carefully. That if somebody says no, it doesn't mean you keep on coming back, because then you are repeated. Somebody said to you no. If you keep coming back after they've said no, that is repeated, and then you are running into harassment.
So actually, you are saying to me, a no is a no in perpetuity. Really?
Yes, unless somebody comes to you and says, I've changed my mind.
Yes. And if I told you that expert evidence you've just given doesn't take into account a number of cultural practices, prevailing cultural practices about courting, and I'm going to give you a couple of words. You should know them because you are an expert. You've ventured in. Let's take in Xhosa. The word "ukasa." Are you familiar with it?
No.
Are you familiar with the Zulu word "ukushela"?
I've heard it.
Are you familiar with the word, it's another Xhosa word, "ukuphimisa"?
No, I've not spent time in the Eastern Cape, so I'm afraid
All right.
I'm not going to be able to recognize Xhosa.
But okay, let me help you with what they connote. It's an exercise of courting between two people. As you said, it's men, usually. In fact, it's frowned upon, I think, if it's not a man. But let's say, as Dinoa told us, it happens. Would you differ with me when I say those three words emerging from those particular cultures? We can criticize those cultures if we like. In them, they connote and involve persistence, pleading. In fact, the word "ukushela", even outside courting, is suggested to mean pleading with somebody.
That may well be correct.
Yeah, so I'm saying when you are not aware of particular cultural notions, you can miss in language a discussion between two people of a particular culture if your interpretation comes, one, from a position of ignorance of their cultural exchange, their culture, right? Or you come from a position of what you would call a superior culture. It means a culture that assumes, usually Eurocentric, that its understanding of things, including romance, must be universal. And I'm putting it to you that in a discussion between two people of a particular culture and region, it's inaccurate to impose your interpretation in relation to that aspect.
Again, are we talking about workplaces or outside workplaces? If it's outside of workplaces, that is a different matter. In a workplace, there are particular rules about how you engage. I think the other thing one has to take into account is that this is possibly one of the most thorny and contested areas in South Africa, are these questions about culture. and the Constitution.
Yeah.
Is the Constitution the supreme law of the land? Does the Constitution set what are some fundamental or basic values and norms that we should all adhere to? Or does it say, no, we don't? So I think those are the kinds of things that one needs to look at. And as somebody who comes from a different culture, it has certainly long been the norm as well. And this, I think, has been the criticism. That when women say no, they mean yes, and therefore you should persist. It is not unique.
Please don't bastardize the suggestion I'm making of respect. I know exactly. I know exactly in what cases a no means no. I'm just raising an issue to you that may be an oversight on your part. Please don't reduce what I'm saying to suggest that I don't understand circumstances when a woman says or a man says no, they mean a no. I was just saying to you, your analysis may be deficient when you are analyzing a conversation between two people about a subject matter that has cultural implications in how it's handled. That's all I was saying. And your reference to the Constitution is a little offensive because you are suggesting that in the notions I'm telling you, those notions of cultural interactions are somewhat inferior or violate the Constitution. I was not suggesting that.
That's not what I'm suggesting either.
Okay. So do you accept with me? The Constitution does not talk about what we're talking about here. Courting, flirting. It doesn't. So I don't know how you brought it up.
This is what I was talking about with blurred. One person's courting and flirting might be another person's harassment. This is precisely why we end up having sexual harassment matters, because the one party will say, but I was simply appreciating her. I was simply complimenting her. And the other party will say, that is not how I felt. That is not how I experienced it, and what it was unwelcome to me.
Yes.
That is precisely why we have these disputes, because there is contestation over what is it you want, who determines what you want, how do you communicate what you want. So we try to find ways in which we can arrive at some kind of more or less a set of norms.
Yeah.
Where we can interpret and understand each other. The Constitution attempts to try and do that.
Yeah, but I'm going to move from this subject.
All right, before you move from it. When Mr. Sikakane put those three concepts to you in relation to courtship and how they may be put in practice, you said, here you are talking about a work relationship. Your suggestion then that the work relationship trumps all those practices, or you are not saying that?
I'm saying this is why it gets very tricky. Is because you have a workplace that sets out one set of rules, and then this is where it becomes so difficult, is you have a workplace that has quite clear sets of rules. The professional, that is, you are supposed to keep separate from the personal. And then when the personal comes in, it can be in conflict with the professional. And that is where the dilemma can sometimes arise, is which do I respond to?
Yes, yeah. Well, if your answer is that there is a dilemma, then that's sufficient answer. Because I just wanted to know whether you are saying that the work situation trumps those cultural...
it creates conflict.
Yes, all right, that's fine. And before we move on, can we just for the record, please, Mr. Skakani, just spell out those three concepts in writing so that when people transcribe the record, they don't create their own words.
Yes, I will try and assist. And I'm no expert in the three of them, but I know how to spell them.
Yes. Yeah. Please spell them for those who are going to transcribe the record.
Yes, I will do so too. Yes, and you know in this case, and I think it's on the record that we're not furnished with a policy that regulates that in this particular case.
No, no, you're not.
Yeah. So it's an area that is unregulated. But as I said, all I wanted you to understand, at least to agree with me, is that this entire conversation requires an expert in order to interpret what people are doing and saying, to also be aware that it has its own cultural insinuations that are more important than the experts' idiosyncrasies and views.
There is certainly culture to be taken into account, but culture is not the only thing that is at play here.
I didn't say so.
Yeah, so I think that is what one has to bear in mind, is that culture is clearly an important factor, but it is not the only factor.
Yeah.
So there are other things that can be looked at in addition to that.
Please assume that I know those basic things about life. And then if we get to, let's get to the yes or no. Yes in perpetuity or no in perpetuity. I know this may not change your view. If I told you that in the record, the complainant, and I'll take you to page 1265 of the record.
You'll have to give me a date. I don't have numbered.
Oh, you've got them as dates. And I think it's 9 October 2021, the conversation. 1265 specifically. It's a conversation at 13 minutes past 9, 21:13.
Yes?
You see that, oh yeah, sorry, Chair, sorry. 1265.
Thank you.
You may or may not agree with this. It's that conversation. Yes. It's a discussion. It's a conversation they are having about a very important case about consent.
Okay, so it's the 14th of October.
Yeah.
The Kokoro matter.
Yes. And the complainant's views are expressed there about consent. In fact, I think she says that once, and I'll read, ifundisa xokela ukuba ebeyazile complainant ngokwangoku ya ukuba ukuthi yes kwakhe koyokuqala akho boundaries for next. One thing led to another way. Says if he agreed at the beginning, there are no boundaries after that. There is no after that yes. What's your comment with the complainant's views? Because she differs with you on the perpetuity or non-perpetuity of a yes. She says this woman who ended up in this situation, raped by someone who claims, no, you agreed that I kiss you. Her view on this issue is that the first yes meant no boundaries after that. It's interpreted in page 1331 if you want to get the English version. And I can read it to you. It says, it teaches you to be suspicious. If the complainant knew then that when you say yes to the first request, then there will be no boundaries for the next. Those are her views on yes.
I did look at this and was thinking, there are two ways to interpret that. The one is so that if you do allow someone to touch you, then whatever happens thereafter is you've given permission to. Or the other way to interpret what she's saying is that if I say yes, then it's assumed that I'm saying yes to everything thereafter. So I read that as saying potentially two things. It's a bit ambiguous.
Am I wrong, Ms. Lisa Written, that actually every time we interpret what she says, you are more sympathetic towards her, to interpret it sympathetically than you do with the respondent?
No, I'm saying there are two potential interpretations here. Either one could be rare. Either one could be right. Okay. This is one of these occasions where you'd have to say to her, what did you mean?
It's fine. I'll leave that. I'm going to go to...
Because I can agree with you. She's not entirely sympathetic to the complainant. That's how I will agree with you.
That's why I was leaving it, Ms. Lisa, because as an intellectual, I expect you to have a much more open discussion with me than evasive. So, but I'm happy if that's the... Because I think those views are at odds with your view.
Which view?
No, I'm saying if she says a yes, is a yes in perpetuity. If that's the one of the views.
As I said, there are two ways you can read this. If you yes to the first request, you can place on it. The other is if you do say yes to something, it's going to be taken to mean that you've said yes to everything else. Two meanings. She would have to clarify which one she meant.
All right. She would have to clarify.
Mm.
That's why we get back to the point that actually it's important to establish from her what she means about things, rather than to interpret them sympathetically or not sympathetically from a distance. It makes the point I was making to you about faced with what your interpretations of what she does. I see now that you, for some reason, now you respect the fact that it would depend on her. And that's what I was saying to you earlier, is that faced with what she says and does, we've got to give weight, as you do now, to her intentions and what she means. This is a 42-year-old woman, smart, divorced, has been through life, and knows what she means, and says what she means, and means what she says. You and I have no reason to doubt it. Do you disagree with me?
No, but that doesn't mean she always knows exactly what she wants. I mean, we must assume that she went from a position of not saying anything to laying a formal complaint. Clearly that shows that she has changed her position.
How do you know that?
Well, presumably she would have gone to lay the charge at the first time she was
how
offended.
do you know that sometimes she knows what she means, sometimes she doesn't?
Well, we assume if she's gone to report now, she now knows that's what she wants to do. That's all I'm trying to say.
As a person, how do you make the conclusion that sometimes she knows what she wants, sometimes she doesn't?
No, what I'm saying is what she wants might change over time. At the time she didn't lay a charge, she then laid a charge. So her thinking has changed over time.
Can you dispute the fact that as an adult, employee, educated person, we must respect that she knows what she wants, she means what she says, and she says what she means? You and me have no particular legitimate reason to doubt her unless we state why. She's no imbecile.
No, of course not. Well, if you look at the WhatsApps here, and if you look at her testimony, she does say to you, sometimes I am playing along. So sometimes she's saying, I am doing something different to what I am saying.
Yes, that is the part I said you would have known better and analyzed better as an expert had you seen or heard through when those statements are tested in cross-examination. You agree with me that, and I don't dispute what you're saying. I'm saying your analysis would have been enhanced and more objective and more complete had you had sight of what exactly did she say when those things were challenged. Did she concede? Did she say the opposite of what we are saying? In this tribunal, not when they are flirting. Because I accept that you say when they are flirting, because one is a judge, the other is not. Therefore, I'm saying, if I were to show you, if you had read the cross-examination, it would have enhanced your analysis and would have impacted on some of the things you assume because you don't know what she said and what she conceded.
There are some things she did concede, but I think the substance of, I would not change the substance of what I said, having gone through the record. There are places where she disputes your interpretation, says something different, remains committed to her interpretation. So she does not give way on everything.
You would not change your view even if you see what you have not seen. It's a bizarre statement.
No.
You would not change. You don't know what you've not seen.
I went through the record last night. So now I have seen it. I cannot comment on a lot of the cross-examination about was there a grammatical error, does the full stop look the same, why are there two statements. That is not something that is for me to comment on. It's not for me to comment on whether or not WhatsApps were cropped or weren't cropped, what time things were. That falls outside what I'm doing. What I was looking at is where you are cross-examining her around what she said.
I'm saying, ma'am, when you gave us the report and when you gave your evidence in chief, you had not had that access. It's an ex post facto analysis you are making.
I had skimmed through it, and I had listened to what was said in the media, which was essentially the Judge President saying, yes, we had flirtatious conversations, but I thought it was I thought it was reciprocated and was flirtatious. That seemed to, and in the opening of the evidence leaders' statement, she also makes a fairly similar comment that this was he assumed it was flirtatious and was returned. When I go back and look at the testimony of asking for photographs, those were repeated requests. My opinion doesn't change that he asked repeatedly for a photograph and she didn't give it to him, no matter how many times it was repeated. I don't see any reason to change that. There were also the times where she was repeatedly asked about what is her favorite sexual position. She does not specify, oh, I like X, Y, and Z, and I like it like this in that conversation. And I also looked at the areas where I identified that she is engaging with him, and they're the same as the areas where you identify her as engaging with him. So on that.
Yeah, all I'm saying, ma'am, is what we established yesterday. I'm saying it would have enhanced your analysis, your evidence in chief, and your report. That's all I'm saying.
Possibly.
You must agree with me that when you've not looked at a particular aspect of the record, your analysis is incomplete. You must agree with me. It can't be that you undermine what you've not read. You don't know what you've not read. And I'm telling you now that reading the record on cross-examination would have enhanced, I don't even say, would have enhanced your analysis.
It certainly would have given me a clearer sense of where you are heading.
Yeah, I'm assuming, Ms. Vetten, I'm making this conversation, I'm going to stop it. I do it because I'm assuming that you are not the complainant's witness in these proceedings.
No, I'm not.
You are the witness to assist us with concept, to analyze for us, to assist us, not to support any party. That's why I'm engaging with you. When I make this point and you duck it, I'm not sure why, because I'm saying to you, you must agree that not being furnished with certain things, or not having access, or not having read a particular aspect of this case, particularly how we, in proceeding like this, test the veracity of claims, renders or may render your analysis deficient, your conclusions inchoate.
I don't agree. I think it would certainly have given me another perspective, but I think on my conclusions is, did he repeatedly ask her for photographs? And did she provide him with a photograph? Did he repeatedly ask her about sexual positions? Did she say no to him? That would not change.
I don't think we should proceed in this manner. Mrs. Vettel, the question is, you admitted you had not read
Yes.
some material,
Yes.
such as cross-examination. You had not read the respondent's affidavit and the like. The question is, do you agree that had you read those things, they could have enhanced your report?
They could have.
Please, yes.
Thank you. Can I take you to the conversation about pictures, right?
May I go to the bathroom?
Oh, yes, by all means, yeah. Maybe, Chair, I think she...
You might not be the only one.
I think she speaks for
Let
most
us
of
come
us.
back at 12.
Okay.
At 11. Chair, that's a 2-hour, 1 hour. You've just given us 1 hour, 15
sorry.
minutes.
I'm sorry. I withdraw that. At 11 o'clock, please.
Thank you, Chair.
We adjourn now.
So, bye.
Thank you.
Mr. Simelan. Sorry, don't sue me for that.
It depends on my bank balance. I reserve my right. Ms. Vetten, I'm going to just cite a few examples of the things you omitted and things that I would like to get why you interpreted them the way you did. Can I take you to page 1165? It's the conversation, sorry. I know you're working on this. 8th June.
8 June, yeah?
Yes. It's 2028 time at that. Yeah, it's a conversation. Well, just a conversation.
2028.
You see that emoji, winking emoji at 2028.
Mm-hmm.
You gave it some interpretation that it's deferring. Remember that?
Mm-hmm.
Dr. Doctorate gives it another. And he's the expert on emojis, I suppose. He says, she says it's flirtatious. Should we take yours or hers?
No, I'm not commenting on the emoji. When I'm talking about deferring, it's when she's saying will do.
So,
the winking you can read as part of agreement.
Yes, okay, so...
But it's will do, wink, agreeing.
You take no... I don't know, she just said it's flirtatious. I don't, do you want us to take yours or Dr. Docrat? You're saying it means agree, but I'm saying to you, she said it's flirtatious.
Well, as a description, it's somebody winking.
Huh?
As a description, it's somebody winking.
Okay, it's fine.
The meaning you can attach to that.
It's fine. Can I take you to 1167? Can I take you to the conversation? Am I correct that you said she didn't send a picture or at all?
She put up her profile picture.
Okay, so she did.
Yes, for everybody, but she didn't directly send a photograph to him, as I understand.
That's fine. So it's that, but it's in this conversation. She sent it to him.
A profile picture.
Yes.
Yeah.
Huh? It's not. Are you sure it's a profile picture? Are you sure that it's a profile picture? I'll give you some time.
Well, that was my understanding from the evidence, was that it was a profile picture.
Okay. That's what you were told. Okay, no, that's fine. All right. We will.
And I can't see it clearly. I unfortunately can't see any pictures or videos or.
No, it's fine.
Stickers.
It's fine. I'm really not. Yes, I think it's an argument. We'll make an argument. I think you. I get your answer. Can we also go to 1169? There's still a conversation about pictures.
Remember, I don't have the page numbers.
Are you there? Sorry. If you convert the date, 8 June. Still.
Yes, but I would need what time?
Okay, sorry, I'm going to get there. Look at 2053.
Yes?
Yes. I mean, this probably links to the aspect of coaching we talked about in a way. She says, earn it. What is your interpretation of what she's saying?
She says, so if I look at the context, it's you are a trickster. Then she says, do you see what I have done, what you want me to do? And then her comment is earn it, which is in response to his,
Persistence.
yeah,
Yeah.
no ways,
Yeah. What
persistence.
she says, she must earn it. He must earn it. What is your interpretation of that? When she says earn it, means when if I to give you for me, earn the picture.
Yes, you can certainly interpret it as that.
Yeah. No. I'm saying that she says earn it. What? Give me yours. Give me yours.
So, in the context of what they're saying, of what they're saying, it's a picture. Then it's a profile. It's a picture that he doesn't want because he says he'll wait for something else. He's been robbed. I've been fooled. She says no ways. He says you're a trickster. You're playing tricks on me. And she's saying to him then, do you see that I've done what you wanted me to do? I sent you a picture. Earn it.
Yeah, I think that's the question
Yeah.
I'm asking you. What does that mean?
That he must earn a picture.
What does that mean? What's your interpretation? To earn it, how? What must he do?
She doesn't say.
Okay, and what's your interpretation? Any interpretation?
Well, she's saying to him, earn it, but without explaining how it is to be earned.
She's inviting him to do something. Earn it. Would you disagree with me?
You could say that.
Yeah. But you agree with me that she's not deferring there. She is positively stating what he must do. You and I can differ about what it is. But she is telling him to do something.
Exactly, which you can say is she is deferring. She's saying to him, these things need to happen
Ma'am,
before I send it to you.
I think I want to put it to you that I did tell you about this. I expect you to give an objective analysis rather than a sympathetic analysis to one party. I put it to you that in every interpretation, you are sympathetic towards a party in these proceedings. You give an interpretation that does not put a particular party in the bad light, despite what she says. I put it to you that that is what I have observed.
Let me explain to you again. When
Yes.
I say defer, I'm not going to. It means I'm not sending it right now. Things must happen before I send it to you. That is a form of deferral. The moment is deferred until you do X, Y, and Z. So now she's saying to him, earn it.
Okay,
Do
listen.
whatever you need to do, which she doesn't specify, in order to get your picture.
Okay, let's see how you deal with the 1170. Let's see. It's a conversation at 9:10. She says, "Yazi bamna xa ndifuna imali uzandinika." She says she wants money. You'll
Yeah.
you'll give me money.
Yeah.
What was your interpretation of this?
That was being quite blunt and crude. That if there is going to be anything here, it's going to be an exchange. It's going to be a transaction.
Did you hear my question?
You asked me for an interpretation?
No. I said, what did you say was this meant yesterday? You did mention it.
What did I say?
What did you say this meant?
It was being crude and blunt and repellent because it is a transaction. She's asking for money. That's what I said.
She's asked quid pro quo.
Yes, if you want a photo, then you send this to me.
Yeah, you will give me
Me
the money.
money.
She was transacting
Correct.
with him. You agree? Well, the other one I want to take you to, that gave me the thing now, is you omitted where she actually says, I think it's at 12:05. Let's go to 12:05. 19 June.
$12.05, you said?
Yes, page 12:05. It's 12:05. It's
Which
right.
date?
It's 22:24.
Which date?
Sorry, Ms. Witten. I know that we open it. It's 20 June. Sorry.
Okay, 20 June is quite a long conversation. So what time did you say?
Yes, 24 minutes past 10 in the evening. 22:24. She says to him, cute. And I'm saying this because you made a song and dance about people initiating or saying something after hours. You omitted this. Is there any particular reason before I put mine? You omitted where at 20 past 10 in the evening, she says to the JP, you cute. Is there any particular reason why you omitted this one?
No, I have mentioned that this is in the context of conversation that's been going on throughout the day. And I did mention that she does describe him, I think there are 2 occasions where she makes a comment on his appearance.
Yes.
Where she says cute, and then it's followed into, but weren't you younger then, or whatever. So there are two occasions where she does comment on his appearance.
It's fine, and let me take you to the other one, 12:06. It's still, and I'll tell you they are not just 2, but I'm going to take you to the one at 12:06. It's a conversation. It's still the same date. It's at 22:27. The time. She says it again. She says, cute londo. See that too. And this also she does at night herself.
Is this not the same one?
Huh? I don't know. You tell me.
Okay, right. I see the sequence now.
Okay.
Okay.
Yeah. I'm putting it to you that, and I'm not doing this to nullify your views about the inappropriateness, as you called it, of the conversations at night by the respondent. I'm not now talking about whether he was appropriate. You said it was inappropriate. I'm saying when she does it, when she tells him you're cute, in the evening, are you prepared to call it inappropriate from her, or blurring the lines between this little girl and the father figure?
Yes, and you can see in my report, I describe some of her responses as being ambiguous.
Yes.
She is not clear all the time.
All right. I'm going to take you to the last one, where, and it's an old conversation, it's a long conversation, it's fine. I think we've made the point about, it's the one where they're discussing sex positions, right? I would like to take you to that one. That eventually, yeah.
It's at the end of June.
Yes. So, sorry, Chair, I'm just going to get to it. It starts at 1191. Let's go to 1191. You will see, I'm going to take you to the specific. Yes. 119. Let's go back. In fact, that whole conversation ends. It's the conversation of 16 June, sorry. Yes. See that the specific time Okay, in my page it's 1195, but the conversation, it's at 1816.
Yes.
Your interpretation of that conversation when she says, I'll go with whichever, I suppose sex position, we agree. But there's a word I like. And then she said, surprise. Am I correct that your interpretation was that she is refusing to commit?
Yes.
Would I be wrong, because now we are in the murky area of different interpretations, would I be wrong that wanting to be surprised with a sex position is a preference on its own? It's not doing nothing. When you say whichever position, it means I like all of them. Surprise me. Would I be too wrong to say that is a particular stance on the issue? She is giving a preferred answer, position.
Yes, she is. She's not being specific.
Yes.
She's leaving it open.
Yes, but I'm saying to you, let's just intellectually be rigorous about it. It is a choice she's making. She says, I like whichever.
Exactly.
She's not the same as someone who keeps quiet. It can't be.
Yes, she says, that is correct. She's saying to him, surprise. She's not saying exactly what she likes. She says, surprise.
No, she does.
Look,
she says she'll go with whichever.
But what I am interested in is the conversation that follows it. You can't not have a favorite position.
It's fine. I'm not there.
Okay.
Don't go to analyze the one I'm not. Let's not avoid this one.
Sorry, Ms. Vetter, do you have a problem if somebody says to you, this is a pertinent statement, which says, I will go with whichever. Isn't that a pertinent statement?
Yes, it is. She is telling him something.
Very
That's what I've.
Very pertinently.
Yes, she's saying to him, I'll go with whatever. But my point is that she is saying something to him, but she's not specifying the position.
Well, Mr. Skakane said yesterday. You said that she's refusing to comment.
To commit, she's refusing to give.
Commit.
She's not giving a particular
Sorry.
position. That's my point. That's all. So why I highlight that is she says, surprise me. But it's what comes thereafter is lol, and then a pressing for, but you can't not have a favorite position.
But this is
That's
a
looking
pertinent.
at context.
This
yeah.
is a pertinent statement, which says, "I will go with whichever."
Yes.
That's a very pertinent statement.
Yes, I'm not disagreeing with you. Her statement is...
Yes, go ahead. Proceed.
Yes, Chair. I'll proceed. So, those are parts that I wanted to engage you on. The part I wanted to... Okay, Mr. Madonsala has another. But I'll get to it. I'll get to it. Let's go to 1228. Sorry, Chair. 20 June. Right, it's fine. I want to take you to the conversation, the date you omitted as well. That's the date of this conversation, it's 23 June. It's at 1946.
'23.
23 June.
Yes.
So, and it's at 1946. I'm just pointing out what you omitted. And she says, "Uyaniphazamisa and igazi lami liyatshisa ngoku maniqale ndigqibele." You see that?
Mm-hmm.
You know what it means?
You are disturbing me and now I'm getting heated up. Let me finish this first.
Yes, you omitted that.
It's an example of the statements that is ambiguous.
It's fine. All I'm saying is
Where I said, you can see that there is an exchange happening.
it's fine. Let me go to the following one at 1948. Same conversation. And she says, Shalubawa, I like it. I like it. Okay, there's a grammatical error. I like it that. Kwenzeke ufike unomhla.
What page is that?
Oh, sorry. It's 1229, the page.
1229.
Is it the one of you're disturbing me and now I'm getting heated up? Let me finish this first.
No,
or
we've
is
done
it
that. Yeah.
keep on drooling, I like it so that when you arrive you'll be interested. Is it that one? Yeah.
Yes.
What time is it?
It's at 1948. It's the, if I put it to you, you omitted. This is someone
I
clear.
didn't.
You didn't omit it.
No.
All right. I'm saying the interpretation. I'm sorry, you didn't omit it. This is someone who's inviting, who says to someone, "I like it that way. I want you to come to me, desiring." If I put it to you, that's not the language of the person you are describing. Who's a passive person who's doing something is being done to them,
No, I'm not saying she's a passive person.
right?
If you look at my conclusions, is that she tries to exercise what agency she can within the constraints of her particular circumstances. There are times when she does engage with him as a way of trying to resolve the situation, is to think, and in fact this is something that she says, I say no, I do this, I do that, it doesn't work, so now I engage. And you can see this happening, and this is your point, that the way they engage does change. And you can see this towards the end of June, July, that she does start to engage in she starts to engage in a sexual way. This is a definite example of it, as is the other one. So is the example about foreplay. So this is why I'm saying it's quite important to draw distinctions between different acts here. This is what I would call sexting. And her sexting, I think, with him can be a lot more ambiguous than her responses to photographs and let's meet and be intimate.
All right. I'm going to ask you again to stop giving some sympathetic interpretation to this. She is asking him. She says, I want you desiring so that when you come to me.
And I'm
You must
agreeing
have-
with you. She is
Yeah.
being open here.
And I've said it to you because this does not paint a picture of the person you consistently want to paint.
Not necessarily. I've said to you, she gives ambiguous responses. And
This is not ambiguous.
No, it's ambiguous in the sense that if you read it with some of the other things, it starts to become... the question you ask is, this person is giving quite different responses at different times.
You know what the problem is, Ms. Witten? Is that when it comes to the complainant, you are prepared to give very sympathetic, long-winded explanation for what she says, but you don't do that when you interpret what the respondent does. And that's what I was asking you at the beginning, that as an expert, you are not here as an advocate for complainants. You are here to interpret, give objective expert evidence. But I'm putting it to you that when it comes to her statements, you give them a sympathetic interpretation, but you don't do the same when interpreting what the respondent says. It's quite blunt, actually. You inappropriate, church elder. You're quite very daring. And that's what I'm putting to you, that you are sympathetic to a party. This is not ambiguous, this statement. This is not a child talking to a father.
No, and that's my point is that her conduct does become ambiguous. It is this point, that at times she doesn't say anything, then she does engage, then she is evasive. The complainant, the respondent, is pretty clear about what he wants.
It's fine. I'm going to
That's
put
not
this
a problem.
bluntly.
Well,
Let
it's
me
very
put
clear
this.
what he wants.
She is telling him, I want you to desire so that when we have sex, you have energy and desire. This child says so.
Exactly. And she says
She
so.
never says, the complainant never says she wants sex. The question must just be rephrased.
Yeah.
She understands.
She understands what
She
I'm
has
saying.
the words in front of her.
Yeah.
She should just answer the question.
I'm saying she's not ambiguous. And she's asking for that. I want you to have energy when you come to me. And I'm not asking you to abandon your complainant. I'm saying let's be honest about interpreting statements and not be sympathetic to anyone. I'm saying this statement.
I
I'll
agree
put it
with
to
you,
you.
and it's one I've highlighted.
Yes, I'm putting it to you that this statement is not consistent with your description of the complainant in this conversation. No child says this to a father. Not that I know.
I think this is the point I was trying to make to you about her dilemma. She sits within a position where she works with somebody, where he is also approaching her sexually, and where she also needs to have respect for him as this father figure. There are times when she responds differently from different positions. This is one where she's clearly focusing, where she's clearly responding from male to female or man to woman.
I'll tell you the danger with what you're doing. Is that you are giving a generalized interpretation which is sympathetic. And this is the deficiency in your testimony. Because you did not speak to her. You are imposing your own, as I said, idiosyncrasies, your own generalizations, and your own inclinations in these issues. Had you spoken to her, is it not possible that she would have been blunt and tell you that's what she wanted?
That may have been the case. As you say, I didn't speak to her, so I don't know.
Yes.
Mrs. Vettel, is there any ambiguity in this statement?
No, there is no ambiguity. Her responses are what I'm trying to, perhaps I haven't put that sufficiently clearly, is that when you look at the context of times where she is saying no, 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 and then she gives a response like that, that's where the ambiguity comes in.
But why do you bring the other things when we look at this specific statement, which stands on its own, written in partly in Xhosa, partly in plain, simple English?
It's back
Does
to
it not say what it says?
It does say what it says. My point really is trying to understand, which is what I said at the beginning, is what I am trying to do is in the context of what she's been saying over time and how the conversation is shifting, in what direction is it shifting? Here she is being pretty overt and sexual, as she is in other places. There is that kind of sexual exchange, and the sexting that I talked about is some of the actions. That is what I am trying to say. There are times where she is explicit, and that is where the ambiguity, the evasiveness, the tricksterness that Mbenenge is referring to comes in, is that there are these times where she is saying no, and then there are these times where she is giving these, let's do this. That is where it
Ms.
becomes
Vettel, sorry to
unclear.
interrupt you. I was just asking whether the statement is ambiguous. You have answered my question and you said it is not ambiguous.
Yes.
I'm happy with your answer,
Okay.
unless you are not happy with your
No.
answer.
Did you? Yes, just the last two questions. Did you have access to what we've called in the record the to dispute it because it's on the record, that in the original, let's call it the initial complaint, consistent with these omissions, the complainant in the statement, in the complaint about which we are in these proceedings, excluded what she had in the initial, which demonstrated violence on her part, belligerence towards a court manager. Were you aware?
I know that there was a conflict with the court manager, and it comes through in the
Yes.
threads. So
But
I was aware of that.
Yes, when I'm just giving it to you because it's consistent with what I was saying to you. You've got to analyze a certain conduct of a person you say fears authority. When she omits initially, she has a complaint where she writes about this belligerence of her physically confronting and stopping a supervisor, authority of the OCJ. And of course, because that's not consistent with someone who is a little child who fears authority. I just thought I wanted to raise with you that she omitted it when she did this. And the point I was putting to you about that, because it's on the record, is that it's omitted because the first one indicates a person who is not timid, who's not docile. He doesn't submit. He's actually a very, very assertive person. It's not the person you are describing. Somewhere she uses words like uyanya, you shit.
I don't have that in front of me.
Yes. I'm saying because those are on the record. Would those statements, someone who says to someone uyanya, someone who's authority, would you agree with me that person cannot be described as a submissive, docile person?
Under those circumstances, no.
Yeah. Let me ask this last question. I asked Ms. Mengo this question, and I think it's better directed at you. Because you've testified several times, has it happened that there are complaints that are illegitimate?
Certainly.
Have you experienced false complaints?
Yes.
Would you agree with me that it's actually false complaints that undermine great work that people like you, and there are very few, and I'm not patronizing you, Lisa, you only, in this country, you are a leading intellectual for women on that aspect. Nobody writes, nobody has actually done this for women like you've done. And the point I'm putting to you is, does it undermine 30 years of your work and others when false claims are made, in your view?
That's a question people often ask, and the answer to that is only if you think that all women are the same and that if one woman lies, therefore everybody else lies. So, you know, when somebody lies about their house having been broken into in order to claim insurance, we do not, therefore, start to doubt everybody who now goes and lays an insurance claim. And that's the attitude we should take with these. One should make them less exceptional. We should allow for the fact that, yes, some women will not behave well. And the fact that some women behave well doesn't mean that all women behave well.
Yes.
And when one woman is not truthful, we shouldn't take that to mean as, reinforcement of the stereotype.
I didn't mean that. I know you're doing that to me, but I didn't mean that. You know what I mean. I'm not suggesting that when people generalize, they are right. I'm not. I know you're jumping to that because you want to nullify this point I'm making. People do undermine great things because the conduct of a minority or even of one person. It may not be right, but people generalize. People say so many things about black people when they've met one black person who did something. So I'm saying conduct of a person can undermine great work. And I'm saying to you, false claims may undermine great work in this patriarchal society where women are facing gender-based violence every day and sexual harassment every day. And it's a patriarchal society because men deny the sins they commit. And if even if it's one or two that make false claims, they perpetuate stereotypes and useless defenses by males who commit this. That's all I'm putting to you. That it does undermine great work. This term, sexual harassment, you will know, emerges, people grapple with it in America since 1970s, grappling with it, and you're still grappling with it. I'm saying to you, a false claim, as you say you've met some of them, undermine great work of few people like you who've been working under testing circumstances. It undermines that work. It has the effect of undermining that work. Do you agree with me?
If you allow to. Mr. Sikakani, so I think it's important as part of my work to try to push back at that kind of stereotype and at that kind of generalization. Just as it is important, as you point out, to say that because one black person does something bad, you do not generalize, and so one should always challenge any kind of generalization. So that would be my response. Does it undermine? Well, if one person can really undermine 30 years of bad work, and the point is, why would you want to focus on all those who go and ignore all those who are invisible? We're watching a case now.
It's fine.
We're not seeing the cases we don't.
It's actually, I put it to you that conduct of a few people can undermine great work of many people in circumstances where we're dealing with what you say is a patriarchal society, male-dominated society where males deny what they do and say claims are false. It does, you may not agree with me, that when one is found to be false, it has an impact on those who have true claims. But I suppose you don't agree with me for your reason.
It may well have an impact, but one must resist such generalizations
Sure.
in order to reduce the negative impact.
That's
So,
fine.
sorry, just to, I understand your answer to be saying, it may well be that those who tell lies here and there, it may well be that they undermine the great job. But it shouldn't. It shouldn't be so, because after all, people lay false claims during burglary to say, to claim insurance and the like, and we don't stigmatize
Correct.
those kind of false claims. Why should we begin to stigmatize almost in general when a few women here or there lie? Your answer is, I guess, it may do so, but it shouldn't.
That is correct. And
Sure.
I think your word stigmatizing is very, very important. And if I go back to stereotypes, the stereotype is that all women lie. And I'd say stereotypical. And we approach women's evidence with caution. So that's why it is important to allow for the fact that, yes, women aren't saints. They will behave badly and they will do things badly. But we must resist temptations to generalize and say, well, therefore we must revert to the previous position where we disbelieved, where we were of disbelief.
Yes, I agree with you. And I have no further question to you. Thank you very much for your testimony. Thank you, Chair.
Advocate Skippers, sorry. Okay, Advocate Skippers.
Thank you, Chair. Just a few questions.
Chair, it's me now who need a look. Can I be excused? No, I'm going to come back. I'm saying, can I be excused? I'm going to come back. Thank you.
All right.
I don't want to adjourn everything for. Thank you.
Well, I don't know. Are you sure of that? Because we don't want to pressurize people here. All right, okay. Advocate Skippers.
Thank you, Chair. You have now indicated that you did read the cross-examination of the complainant as well. After reading that, is your opinion changed from your report?
No, it isn't. It's, as I said, if you're looking at something like sexual harassment, you're looking for something that is repeated and persistent after somebody has said no. And you can see even if you said, surprise me. So are questions about, let's be intimate. On more than one occasion, there is either a very clear no, or there's a whole lot of other things that get said, but the requested item, the photograph or whatever, is never actually forthcoming. So there are repeated and persistent requests. And there is an ambiguity in what the complainant is doing. As I said yesterday, she's by no means an ideal victim, in that she does engage in quite sexual terms at times, and then there are times where she's very definite, no, honourable member, hi. So that doesn't change.
You were also asked about the fact that you don't know the Xhosa culture. But will culture trump something, for instance, where someone persistently says no? Will culture have a role to play here? If someone continuously say no, do you have to look into culture then?
Well, that's a very tricky question. Some people would say yes, but I think if you look at the definition of sexual harassment, it's saying no.
All right, and then with regards to that, I don't know how to pronounce that surname, Koko, judgment, where the complainant made a statement. She referred to what was said in the appeal judgment. Are you familiar with that case?
I am, yes.
You also know that that judgment has ultimately been overruled by the SCA.
Yes.
So that judgment is what was said on that stage is no longer the case law.
Correct.
And the complainant was referring to the judgment.
At that point in time.
At that point in time. Thank you, Chair. I have no further questions.
Thank you, Chair. Ms. Vetten, it strikes me, having listened to your cross-examination today, that the focus of the cross-examination is almost entirely on Ms. Mengo's conduct. And it reminds me that despite all of the legal protections that we have to protect women from sexual harassment, at the end of the day, how we as women behave is regarded as more important than how a man behaves, a man who's your superior in the workplace. In fact, the most senior judge in the province, when he demands sexual photos from you in the first WhatsApp exchange that you have with him, and persists in the face of multiple indications that you and attempts to say no. Do you have a comment on that?
That is how I read what I see here. And I think that is, again, back to some very old stereotypes around it is women who lead men on, women who don't know what they want, who say no when they mean yes, etc., etc. The scrutiny is, as you pointed out, on the complainant. It is why we eventually got around to abolishing the cautionary rule in rape cases, because again, it was, well, can we really believe her because there are all these possibilities as to why she might lie. So we have a very long history of, yeah. And it's the expression you've often had is, I felt like I was the one on trial.
Yes. And what would become clear from the cross-examination and the questions asked of you, or what becomes clear from the cross-examination and the questions asked of you, is that there is a perception that only a certain type of woman can be harassed. And that is someone who is docile, scared of standing up for themselves or speaking out. Is that correct?
I think really that's a question for argument. It's a question for argument.
No, it's not, Chair. That was specifically a series of...
It is a question for argument. It is a question for argument.
Okay. My question is based on a series of questions asked by Mr. Sikakane.
Maybe you should reframe it.
For the record, Chair, I do want to register an objection to this examination as a gross and, in fact, irresponsible mischaracterization of the cross-examination by Madam Chair.
That may be the perception, but that is how I received that cross-examination as a woman.
And that is why I'm saying, people, this is a matter of argument. You can go and argue it when the time for argument comes.
Okay, let me rephrase it, Chair.
The witness has nothing to do with the views that you people are entertaining.
That you people, Chair, you mean the complainant's representatives?
Counsel. The way you see things as counsel, it's not necessarily the way that she sees. And the way he understands that, it's not necessarily the way you understand. These are matter eminently for argument.
Well, let me
don't
rephrase,
bring in
Chair.
the witness to settle arguments between two counsel, please.
No, Chair, it's not an argument with me and my counsel, but with my opponents, but let me ask it differently. Is it possible, Ms. Vetten, that someone who's able to stand up for herself in one context is unable to do it in another context?
Yes, people are not necessarily consistent. And, you know, we feel differently about different people. So some people might be more intimidating to us than others. So, I mean, you can be a lot ruder with somebody because you don't fear them, but you might fear somebody else. And I think that's the point we should always remember with people, is that we would like them to be consistent and predictable and to behave in one way all the time. And including myself in this, we are not like that. You always have to look at context, dynamics, interaction, histories.
Yes. Now, Ms. Vetten, you were asked about culture, and you are not an expert on culture.
No.
So I don't want to ask you about your interpretation of cultural practices. You are an expert on gender-based violence and the experience of gender-based violence in the South African context specifically. Is that correct? Would I be correct to say that culture in the South African context is often used as a justification for GBV and sexual harassment of women? And I don't limit that just to African culture. I'm thinking of even the idea that in South African culture we say things like boys will be boys.
Yes, I mean, I think we sometimes, how can we say, culture is, we all have culture. We cannot get away from it. Sometimes I think there is a tendency to speak as if only African people have culture. And I think Mr. Sikhakhane has made this point numerous times, that the assumption that Eurocentrism, it's universal. But we all have culture. It shapes us in many ways. But the other really important point about culture that one can never forget is that culture is not monolithic. It's not cast in stone. It changes. It's negotiated, and it's dynamic. And you can even see that being said at the Constitutional Court, for instance, in Bay, for example, where they talk about the fluidity of culture, how it's lived. And it's those earlier points that there is what is officially said and there's what people do. And I mean, it's really important that culture always remain malleable and fluid, because otherwise we would still be living the lives of 2,000 years ago, if not older.
And in South Africa, the Constitution and our laws on sexual harassment, the Code, are designed to protect all victims of harassment, irrespective of race, gender, or ethnicity. Would that be correct?
Yes, exactly, because I think one must acknowledge difference and plurality, but there's also a point where you could end up fragmenting things where you have 17 different laws to accommodate 17, 18, however many you want to proliferate. So you do need to have some, what will bind a society together is a common set of shared values, and that, I think, is what the Constitution is trying to do. And it is obviously allowing for recognition of difference, but it is trying to have those common sets of shared values that we, all of us, should be.
Well, I'm not going to ask you about your interpretation of the Constitution, because you're not an expert on that. But the point I was trying to make is that the law specifically is culture neutral.
Yes.
Now, you said in your evidence under cross-examination that sometimes lines get blurred when one person's appreciation, was I think the word you used, is another person's sexual harassment. You recall that?
I do.
Now, is that perhaps why the definition of sexual harassment specifically prioritizes the subjective perception of the complainant, so that through the use of the word unwanted, for example? Could you comment on that?
Yes, it does do that. I mean, I must say, whenever I have been educating around sexual harassment, that is the area where there is always the most tension, is, yes, but I'm just appreciating somebody. Or I am just doing this, or I'm just doing that. And that's when one has to have, I think, quite robust engagement to say, well, you may be appreciating, but what is the other person's experience of it? Do they simply accept what you are saying you do, or do you listen and take their feedback as to how they are experiencing this, and they don't experience this as appreciation at all? And therefore you need to modify your conduct. If this is to be an egality, if we are to talk about human interactions as exchanges between each other where we negotiate how we are to be treated. So yes, that is why you do need to look at what is the subjective impact on somebody. That is, as far as I understand, part of the test, is to look at how does that person experience it, what do they think about it, do they feel it impairs their dignity. It is subjective.
All right. But presumably you have to weigh in on the respondent's understanding of the situation as well. It can't just simply be a one-sided evaluation.
Of course you do. And that is why I think sometimes, and there is that element, I think, of trying to think about what is reasonable, how would somebody outside the situation look at it. And so you do need to listen to, okay, so what is the respondent's understanding of what is going on? How did the respondent, if they were told to stop, what did they do? Did they listen to that? Did they find other ways to get around it? Did they leave? I mean, I'll think of an example where one ended up having to conclude there was no sexual harassment, where he'd initially expressed interest in somebody she'd said, look, I'm not terribly certain right now, maybe, possibly some other time. So he waited 3 months, and he asked her, I'm checking to see if you are interested, and she said no. And he did not ever contact her again. You cannot say that he committed sexual harassment under those circumstances. She'd left it open. He'd followed up. She said no. So in that particular matter, we had to conclude there wasn't any sexual harassment. There are also situations where I think you have to look at what does the person do. So, I'm thinking of a case we recently dealt with. People were offended by his behavior. Was it sexual harassment? No. He might be opinionated and annoying, but what he did not meet that test, did not, I think, amount to sexual harassment.
All right, I want to move on. You were asked, in fact, if you can go to the 8th of June, that's page 1170, Chair. 8th of June at 9:10 in the evening, 2110.
$21.10.
2110.
Okay. Yeah.
This is the part of the WhatsApps that you asked about, where Ms. Mengo says, I wonder if I asked for money, would you give it? Now, this message comes after, so this is at 9 o'clock, 9:10 at night, and the conversation started at about 7 o'clock at night. It's the first day of their WhatsApp exchanges, the 8th of June, so this comes after about 2 hours of WhatsApps on that first night. You were asked for your interpretation of that, and you described it, I'm just summarizing, as transactional. Now, what wasn't put to you is what Ms. Mengo's explanation of that statement was. Under cross-examination, although I stand to be corrected, it could have been in her evidence in chief, but her evidence was that this statement of hers was because she knew that if you asked a man for money, he would leave you alone, he would run away. And that's why she did that. Does that change your analysis of it being transactional?
No, in fact, let me see where I can. If somebody says this to you, it is a repellent and crude. So I would certainly see, so if you put it in these kinds of terms, I would see it as a way of really repelling somebody. Only the most transactional person would engage with this. But to say that, it's a very crude way to say to somebody, okay, if you want to engage with me, then these are the terms on which it's going to be. And either you're going to like it or you're going to leave it. And clearly he didn't like it. And she doesn't pursue it. So that's why it also would seem to me why it would be something that is intended to be a repellent.
Okay, let's talk about another instance in which Ms. Mengo said something that you were asked under cross-examination. It's at page 1229. Sorry, I'm just trying to find how I give you the reference to that. But I'll summarize it. You may be able to find it. It's the section where she said, I want you to remain greedy, so when you come to me.
Linda, there's just one question before we carry on.
Yes, sorry.
I just want to ask Ms. Vetten, where she says, I want money, would you give it? Should you look at it from his perception as well, how he would understand it?
Yes, and he puts his answer there. He is understanding her as asking for money, and his response is life is not about money.
Thank you. The next section I wanted to go to is 23 June. So it's page 1229 of our bundle. And it's 23 June. I think it's 1948. (1946) and then 1948. So the top of the page.
Sorry, 20 June is quite a long conversation, so...
Sorry, in the evening,
in there.
1946. It's 23 June.
Okay, I'm still in 21st June.
Okay.
23 June.
Okay. So you recall that conversation?
Yeah.
And that's very clearly sexual. What Ms. Mengo says there is very clearly sexual. She didn't deny that.
Yes.
Okay.
So there are a couple of examples where she is.
You were asked under cross-examination if your evidence on this was limited by your not having spoken to Ms. Mengo. You recall that?
Yes.
I want to put to you what Ms. Mengo's evidence on this was and ask if it changes your answer. So she was asked about this specifically, and she said, I did not want him to have interest. I wanted to satisfy him, otherwise I would never have had rest. To satisfy him with the conversation as he is continuing with the messaging. I was still in the position where I knew he was my boss by making sure I respond to him. The courage I had in my previous messages, he was not cognizant of that or take it serious. That is why then I sought fit to let me rather respond to him, as this is the response he wants. So that was her response. Do you have any comment? Does it change your interpretation of that engagement?
No, it doesn't. I mean, I think the point I was trying to make yesterday as well was that you see her far more sexual comments and responses coming towards the later end of their engagement, not really up front in their very first conversation. There she said, let's do this, I will do it, the maths is wrong, you'll give me money. It's not really sexual, but it's as you get deeper into the conversation, as I said, it tapers off after 28th of July, more or less, the sexualized content. She does start making these more explicit comments. So I do read that as somebody who, in a previous session, he's asked her about, will you be intimate with me? No. Go and read the Bible. Well, what about it? No, she says. No. And then she has a picture of, honorable member, I am shocked. But he still persists. So clearly this no, the way I would understand it, is she's realizing not necessarily working. So switching to this might be another way to try to engage, to engage, because he does persist. Even when she says no, he does continue. I mean, in various different ways. He keeps asking for photographs. She said to him, surprise me. But he still wants to continue asking about questions around sexual positions. Even when she doesn't answer in the evening, he picks it up again and wants to continue. And she says, are you still asking me about that? So if you're looking at a thread of conversations over time and how she is changing her engagements or how she's trying to adapt or figure out what's going to stop this, that would be consistent.
Yes. And it's common cause, well, you'll have seen on the WhatsApps that despite an invitation by the Judge President or an attempt to meet, that Ms. Mengo did not meet with him, and it's common cause that they never did have sex.
That's right. In fact, she even says to him at one point, are you still asking about that, about the meeting in East London?
Thank you, Ms. Vetten. I appreciate your time today.
Thank you.
Thank you, Chair.
Just as a general statement, I've had an advert about some of these things which says, a no is a no. What is it that you don't understand about no? You are aware of that advert?
Which part of no don't you understand? Yeah.
Yeah, so that's right. So the starting point, I'm sure, should be where it's clear. A no is a no. Isn't that the starting point?
Yes.
Conversely, the starting point should be a yes is a yes.
Yes.
And nobody should second guess a woman when she says no, and nobody should second guess a woman when she says yes.
Exactly. I think the point about...
Sorry.
Oh, so sorry.
Just answer me first. What is your answer?
The yes, you need to look at the context, and I think sometimes the no as well. But that would be your starting point. Is that you
Well,
take...
who thinks they've got the right to second guess a woman when she says no? And who has got the right to think they must second guess a woman when she says yes? Who has got that right?
Well, I think when you are, I'm going to say it in the context of violence, is again the question of...
Sorry, do you find it difficult to answer that question?
All right, put it to me again then.
Hmm?
Do you want to put it to me again then?
No, I'm saying, maybe I should rephrase it. Does anybody has got the right to second guess a no? Does anybody has got the right to second guess a yes?
No.
Well, you answered my question. Do you want, I'm satisfied with your answer. You want to elaborate? I thought it was a simple thing.
If I may elaborate, but I mean maybe that's unnecessary.
Sorry?
If I may elaborate, but maybe that is unnecessary.
Well, unless you want to change the no and change the yes.
No.
If you are not going to change that, then it's not necessary as far as I'm concerned, because I just asked a simple question. Actually, Mrs. Vettel, is it not precisely because it's not because we have got problems, precisely because people think they can second guess a no, and simply because people think they can second guess a yes. Isn't that precisely the point?
That is the point. Or that
Yes.
they can infer yes from conduct when they shouldn't always do that. Like
No.
short skirts.
Anyway, I wasn't talking about conduct. I was talking about a yes.
Stated
and a
verbal,
no.
yes.
Nobody should second guess any woman, because the starting point there's the adult, they know what they want, and nobody should try to second guess their decision. They must respect it. And no is a no, a yes is a yes.
Correct.
Thank you. I don't know if somebody wants to ask questions about whether a woman's no should be respected or a woman's yes should be respected. I don't know if there's anyone who wants to answer a question about that. Ask a question.
None, thank you, Chair.
Thank you. Thank you, Ms. Vettel, and thank you for your time.
Thank you very much. Thank you.
Thank you, Chair. I have no further witnesses to call in the case for the complainant.
Yes, all right, fine, thanks. Mr. Skakani?
Chair, I will open my case with a short statement, but may I take an adjournment? Just want to be sure that when I say witnesses are here, they are. I don't have an instruction about who's available at the moment. Thank you, Chair.
All right, we will wait. And
Chair, before you adjourn, we do need a ruling on what our rights are as the complainant's legal representatives cross-examine, I think, before the respondent opens his case.
we were given around, was it around lunchtime? No, not lunch, it's not there yet. At 11 o'clock, we were given some documents. I don't know, I assume it was your application in opposition to it. We haven't even been able to open that because we're busy here. So we can't even tell you when we will make that ruling because we haven't even seen the first page. We haven't even opened.
I understand, Chair. The difficulty is that we do need to know how to prepare and how to proceed before the respondent opens their case. But I accept fully that all of this has come to you very late, just because of the circumstances.
Yes, maybe let me consult with members of the panel. I think let's come together again at 1:45, during which time we would have hopefully had time to look at the application, and also maybe people will have lunch, and then we resume at 1:45.
Thank you, Chair.
We adjourn until then. find somebody to have to put them in a tent for not having people. Yes, all right. Sure. Thank you very much. I think we're resuming to hear the application by Advocate Butland on behalf of the complainant with regards to their quest to cross-examine the complainant as well as witnesses called in at the instance of the complainant. I think that is where we are. Ms. Butland.
Thank you, Chair. Chair, you would have received our affidavit filed overnight and the one filed on behalf of the respondent this morning. We've set out in our application the basis for what we seek, which is a right to cross-examine the respondent and any witnesses called on his behalf. And we seek the permission of the tribunal to do so because we recognize that it is not a right that we have under the Act or the rules. It is correct that the Act creates no positive right for the complainant to be represented in these proceedings, but the Act also does not preclude the panel from permitting the complainant to have legal representation, or indeed from permitting her legal representatives to be able to do any cross-examination. In fact, our presence here, my and my attorney's presence here through these proceedings, is something that we do by virtue of permission of the panel. It's not something that we have a right under the Act to do. Now, the respondents in their affidavit responding to our application say that they agree on that factually in the statute and in the rules, but that we misunderstand the Act, they say, and we misunderstand the Act because Section 26(4) of the Act says that subject to this Act, a tribunal has the power to regulate and protect its own processes, and their interpretation of that is that it does not entitle the panel to do something which is not provided for, which is beyond the scope of the Act. That's how I understand the argument, but Mr. Skakane will correct me if I'm wrong. We disagree. We consider that the language in Section 26(4) is not unusual language as statutes go. In fact, it's even language that's referred to in the Constitution, and I'll come to that shortly. The fact that this tribunal is entitled to, subject to the Act, regulate and protect its own processes is, first of all, confirmed in the terms of reference as a starting point that are dated 20 March 2024, and that's at volume 4, page 3 to 4 of the tribunal bundle. So what does this power mean to regulate and protect your process? Let me say this first. The tribunal has already made a decision at the outset of these proceedings to allow the complainant's legal representatives to participate in these proceedings. That decision was a limited one, which was to question and ask questions of the evidence leaders' witnesses. And we're grateful for that opportunity to be able to do that, and we hope that that's been of assistance to the panel. Now, I would submit that perhaps one of the reasons that the panel permitted this was an acknowledgement of fairness that's required in this process. And the concept of fairness in a process, not entirely dissimilar to this, was dealt with in the Constitutional Court in a case called Mawande Makala versus DPP Western Cape, and that's 2025, Volume 4, BCLR 399, Constitutional Court. Now, this case was, albeit in a different context, it was in a criminal context, and it had to do with extracurrial statements. But what's relevant is that the court had to interpret a similar phase about being entitled to give effect, to protect and regulate its own process. And what's important is in that case, the Constitutional Court prioritized fairness and the obligation to interpret laws in line with the Constitution. So in that case, the court emphasized that requiring or ensuring fairness in the procedures, in that case of a criminal trial, meant considering the rights of the accused, the ability of the prosecution to perform their duties, and importantly, the interests of society in ensuring that the truth can be ascertained. In respect of our courts, the power on superior courts to regulate their own process is contained in Section 173 of the Constitution, in which this panel will know has been relied on extensively by our courts, often where there's a vacuum in legislation or a vacuum in the procedure that's relevant. And there are many cases in which the Constitutional Court has referred to that. There are early cases, which I'll just refer to, S versus Pennington and another. That's 1997 4 SA 1076, and Parabu and other versus Getz, 1997 4 SA 1095. And those cases essentially look at what are proceedings, what is procedural law, what is the meaning of Section 173. What's important to note is that the wording in Section 25.4 that's before this panel is almost identical to the wording of Section 173 of the Constitution. And 173 of the Constitution has been used in matters of evidence, which are commonly understood as procedural matters, similar to what this tribunal will have to deal with, and in cases where the legislation is silent on a specific procedural question. So we would submit that the question of a court having a right to regulate its own process is broader than what the respondents contend for, that it would have no meaning if you were bound strictly by the terms of the statute, because you have an obligation to interpret statutes in line with the Constitution, and one must do so also being aware and cognizant of the obligation to fairness to all parties concerned. So what should this panel be guided by? Well, we referred in our application, our affidavit, to the Judicial Conduct Tribunal ruling in the Hlophe matter. We accept that that's not binding on this tribunal, but it may give some guidance on how a tribunal approaches and interprets its powers in a not dissimilar process. And in that case, you'll see we've quoted extensively from the case in our application, but it was submitted on behalf of Judge Hlophe that the complainants in that matter, who were the justices of the Constitution, several justices of the Constitutional Court, were not entitled to participate in the tribunal through their legal representatives and to make closing arguments. The tribunal in that case ruled that there was simply no merit in that submission. They also said that the tribunal proceedings are sui generis, they're not akin to criminal proceedings, and that unlike criminal proceedings, they are inquisitorial. The fact that the tribunal is inquisitorial is clear from Section 26.2 of the JSC Act. And to be inquisitorial, we submit, means really a truth and fact-finding exercise that places more of an emphasis on the role of the adjudicators than would be the case in an adversarial system. So anything that's going to assist this panel in performing its inquisitorial task would be relevant to a consideration of how to regulate this process, we submit. Coming back to the Hlophe Tribunal, that tribunal found in its ruling that the participation of counsel for the justices was necessary and was permitted, and that the suggestion that the participation of counsel for the Constitutional Court justices, the suggestion that that participation prejudiced Judge Hlophe, I quote, as merely to be stated to be rejected. Now, in that case, of course, it was a little different because in the Hlophe matter, the issue of the participation of representation for the complainants came quite some time after the complainants had been represented. And the ruling makes that point. It said this has been the case since 2009. So there had been a practice, and perhaps we're not entirely identical to that in the sense that we don't have a practice. It wasn't clear from the outset that I would be entitled to cross-examine the respondent's witness. But we do have a practice of permitting the complainant legal representation in these proceedings. And we do have a practice that, that our role is not that of the evidence leader, that it's there to clarify and to ask questions that are sought to protect the complainant. That's the role. So we would submit that your discretion ought to be exercised in favor of permitting us to continue to cross-examine and to cross-examine the respondent and any witnesses brought on his behalf, as we have done throughout these proceedings. We would also submit, to the extent that this tribunal is going to consider whether or not we have a right to make oral and written submissions at the end of this proceedings, we would ask that we be entitled to do that. And we do so really in an attempt not just to represent the complainant, but to assist the tribunal in its task. So in light of all of this, we respectfully submit that the tribunal ought to exercise its discretion to permit us the right to cross-examine and to make oral and written submissions in due course. And we submit there's no good reason to move from that, from the position that the tribunal has already adopted in relation to us. In fact, it's notable that in the respondent's response, they don't provide a good reason or any reason why we shouldn't be permitted to do so, other than that we don't have a right under the statute to participate. And our response, quite frankly, to that is the fact that you don't have a positive right doesn't necessarily mean that. What's more important is there's no provision in the Act that precludes us from participating. So we would submit that that is important, and that must be factored into the exercise of the discretion that the tribunal has to undertake. Thank you.
Before Mr. Sikakane comes in, let's just point out some of the problems that may arise if we were to do that. We are aware that we have the power to regulate our own procedure, but that power must be exercised, as indeed we felt we did, must be exercised with a purpose, and the purpose is to ensure some fairness, which is why right at the beginning we allowed legal representation for the complainant, and also allowed you to put questions to the complainant and complainant witnesses. But here is this difficulty. Let's start with the Act itself. The Act says only the respondent is entitled to legal representation in these proceedings. It does not give the right for legal representation to the complainant. It doesn't. And that does not look like it's an omission. It is an exclusion. It's not accidental. The Act is very clear. It was aware that there would be a complainant, but then the Act decided to give the right to legal representation only to the respondent and stop there. It didn't give the right to the complainant, for whatever reason. Not only that, consistent with that come the rules which were made under that Act, which does not give the complainant the right to legal representation. Consistent with that comes the rules. The rules say the leader of evidence can cross-examine. The respondent can also cross-examine. Again, the rules do not give the complainant the right to cross-examine. That the rule doesn't. And you can see that that rule is entirely consistent with the Act, because the Act doesn't give the complainant the right to legal representation. And then further, when you come down to the rules also don't give the complainant the right to cross-examine. They are in sync. Now, when you ask us to exercise our authority in regulating our own procedure, do you think it would be appropriate for us to use that privilege, that right which the Act gives us, to then go and do things which the Act excluded and the regulations excluded? Do you think we should do that?
Thank you, Chair. So I think the starting point must be the Act does not specifically preclude the complainant from being represented. It does not say anything about it. And I can't differ
the
from
Act
you.
doesn't say nobody must murder anybody. You can't go and murder anybody and say the Act doesn't.
Fair enough.
The Act enables you. Then you can't say because the Act excludes 1 million things, those 1 million things can be done because they are not prohibited under the Act.
Yes.
When you look for power and authority, you go to the enabling instrument as to what it gives, not what it doesn't, what it excludes, because it excludes everything in the world.
Yes, but it's not, the example of murder is, of course, an extreme one, but we are dealing here with complainants, right? And one anticipates, and I hope the legislature had anticipated, that there will be different kinds of complainants. So often in these proceedings, for example, the complainant is a judge president, because there may be, and there have been many instances in which there are complaints against judges, for example, for not delivering judgments on time. There, the complainant would be the judge president, but he or she is not actively representing themselves and their own position. They are simply bringing a complaint that has been made to them to this forum because it relates to a judge in their division. That is a very different kind of a complainant, and one can see why there that judge president doesn't require legal representation. In that situation, the evidence leader obtains the evidence and presents it, and the judge president is not an active complainant. This, I would submit, is a different kind of a case, and I accept that there are not many of these kinds of cases, and so what we're asking of the panel is for you to go a little further than perhaps has been done. But it would not be that this tribunal is the first to do so. In the Hlophe matter, complainants were justices of the Constitutional Court. They were represented by senior counsel, and they were represented throughout the proceedings. They cross-examined all of the witnesses, and that was permitted. So for you to do that wouldn't be the first time that it's done. That's the first thing. And that ruling is not a 1 or 2 paragraph ruling. It's a comprehensive ruling. It considers this question specifically under its own heading, and it resolves that the complainants were entitled to legal representation, and does so under both the inquisitorial power as well as the power to regulate its own process. So we would submit that while it may seem that what we're asking from this panel is extreme, it's really not extreme. It's asking this panel to take into account that this is an inquisitorial process that requires you to be different to a judge sitting in a high court, number one, and really to do a fact-finding and truth-finding exercise here. How best you achieve that is part of that decision of how you regulate your process. In this case, you have a complainant who is someone who you can see, hopefully, through our engagements, that our engagements were required to put issues to witnesses that the evidence leader did not. And so hopefully that shows that participation is of assistance to the tribunal. And I think that that's relevant, a factor that you must consider. I don't think that you are precluded. I would submit that you're not precluded from permitting legal representation. And that, in fact, to the extent that you were to write a ruling on this, you could even be clear that it is not in every situation that you think it would be appropriate for a complainant to have legal representation. But in this situation, there are circumstances which justify it and would assist the tribunal. So I'm not sure, Chair, if I've answered your question, but I think both the nature of this particular panel as well as the fact that the Act doesn't specifically preclude you from doing this should be factors that you take into account in what is an exercise of a discretion.
You referred to us, to the one tribunal. Is that the Hlophe tribunal? Yes. we have read their ruling. But what is singularly missing in that ruling is how they went about the exclusions in the Act and all of the rules. In fact, there's no reference even to the rules whatsoever. So you read it, you don't find any breach that carries you over that problem because there's absolutely no reference to the rules. So that is one difficulty. But let me, in the spirit of wrestling openly and frankly with this thing, let us also tell you that we spoke to one of the judges who, I first tried to phone the Judge Labuskachne, who was the president of that tribunal. I couldn't get hold of him. Then I was able to speak to Judge Makhuka, who was one of the members of the tribunal. Indeed, he confirmed that they allowed cross-examination in that case, because in the ruling itself it's not clear, but he says they did allow. Then we spoke to Judge Jafta, who was presiding over another judicial tribunal. And he said that the cross-examination was not done in that case. But although he did indicate that the issue didn't arise, but it was not done. Then we also spoke to Judge Japi. He presided in another judicial tribunal. And he said the cross-examination was not done in that case. And he then went on, we don't have to go into those reasons, they may be debatable, but he indicated that he would not have allowed cross-examination. And he mentioned a reason which is arguable, which can be arguable, which doesn't bind us at all. So those are the scenarios that we have. Now, let me come back. You said each case must be considered on its merits. Let me come back to this particular case. And in the exercise of our discretion in the exercise of our power to conduct our own proceedings, we were very much allowed and influenced by the very point that you are making. And we tried to sail as close as possible to the Act, which says nothing, and to the rules, which also say nothing. We tried to sail as close to them as possible. But we're a bit hesitant in violating them, going against them. But we tried to sail as close to them as possible. You know what we did. You know what we did in this case. We said, we said, in all fairness, although the Act does not provide for legal representation by the complainant, we decided that we are going to allow it, and we allowed it. Indeed, we even allowed you to ask questions. And in one of the discussions we had with one of the presiding judicial officers, he was clear that the complainant must, if she has got any, or he has got any issues, must speak to the leader of evidence. The leader of evidence would put those points across. But in this particular case, I think we went a little bit further there. We allowed legal representation, and we allowed you to put questions. And not only did we do that, we have already indicated to you that we are going to allow you to make written submissions. We even gave you a date. So you can see that there is an attempt on us, while the Act and the like are like, don't provide for that. You can see that we have been very mindful of ensuring that there's fairness. We went some distance, and then in the manner that I've explained, to allow legal representation, which is not provided for. We allowed you to ask questions. And we are even going to allow you to make written submissions on our behalf. That's what we've tried our best to do. Now, you want a lot more now. And that a lot more now that you want is what I was saying to you, that it now brings us into direct conflict with the Act. We wish we could just find it easy to resolve that, but I think I'm mentioning these steps that we allowed you to participate in because we want to indicate to you that we're very much alive to the issue of fairness. But we are not the legislator. We didn't make the law, we didn't make the rules. And I'm going to mention this because I want Mr. Simulani, when he makes submissions, says,
Time I'm suing.
Mr. Sikakani, I think I'll refer to Mr. Madonsela from now henceforth, but you must know I'm referring to you. In the event and we're not prejudging, but we're just saying, in the event we don't allow you to cross-examine the witnesses, the respondent, the witnesses, we are wondering whether, as a further attempt on our part to ensure fairness without violating the law, we would say that, yes, the leader of evidence will cross-examine, but you would have the right to consult. You and the complainant will have the right, before the evidence leader comes to put questions, you have the right to consult with the evidence leader, raise whatever issues you want the evidence leader to raise, and if need be, if we have to adjourn proceedings for that kind of consultation, subject to what Mr. Sikakani will do, subject to how they will react. We would even be prepared to adjourn after every such witness, including the respondent, even adjourn to allow you to speak to the leader of evidence as to what issues you feel that she should canvass. It will be up to her, of course, to decide whether she wants to canvass those or not. I'm disclosing in advance all these things because, as I said, we would like you to get a full picture as to how we intend to bring about fairness without violating the Act and the rules. Yes.
Thank you. Let me start by saying we are very grateful to this panel for permitting us our participation thus far. One of the concerns, I said this on the first day, one of the concerns that the Women's Legal Center had, which brought us into the case, was how complainants navigate this process. So this is not just a question for us in the abstract, it's a very real question. So we do appreciate the panel taking the time to really carefully evaluate what it is entitled to do and not do. Our submissions, you have our submissions on how you should exercise your discretion. I'm not going to repeat that. I think that if this panel decides not to permit us to cross-examine, then the suggestions that the chair makes to me about permitting us to consult properly with the evidence leader would be important, and we would appreciate that. Part of our difficulty has been the criticisms of our role and our relationship to the evidence leader, so we've tried very carefully to keep some measure of distance. But if we have a clear ruling that that is permitted, that we're able to consult with the evidence leader before she cross-examines and to raise things, of course she would have to do that with the complainant anyway to get information, instructions. But if we have the permission that we're entitled to do that, we would appreciate that, and we would think that that would certainly assist. Of course, we are at the mercy of the evidence leader. She will decide what she wants to ask and what she doesn't want. So it's certainly not a perfect position from our perspective, but we understand where the panel is coming from. We still stand by our submissions that the panel is entitled to permit cross-examination. Thank you.
Thank you. Mr. Sikhakhane.
Yes, Chair. First, I think it's true that the mission of a tribunal like this is truth-finding. But truth-finding also must happen within the context of fairness. And that's the key word. And secondly, it must...
May I interrupt you, if you don't mind? One of the things that might just be concerning, if we were to allow that, is that the complainant is cross-examined once, and once only. But if we were to grant what you want us to do, the respondent is going to be cross-examined twice. And all the witnesses that the complainant is going to call are going to be will be cross-examined twice. First by the evidence leader, or second by the evidence leader, and then by yourself. Whereas the complainant is being cross-examined only once. Those are some of the things that cause some concern.
Yes, Chair. In fact, the last comment you made, Mr. Matonsala, made this suggestion to me about the expert. He said, can we both cross-examine her? It's true, it's happened yesterday. And I said, no, but that would be unfair to her. You would have, let's see how we field questions together, but it would be unfair to subject a witness to that. And the point I was making right at the beginning is that, yes, truth-finding is important, and we must do everything within the law to find the truth. The problem happens when we interpret fairness to mean we must disregard the law, what provides, because we must assume that the rules and the act, the provisions, the relevant provisions in the rules and the act were made with that in mind. Secondly, I would like the panel to look at the case of the Social Justice Coalition versus the Minister of Police. The citation is 2022-10 BCLR 1267. It's a court judgment. It does help us about how do you exercise inherent power. Because at paragraph 81 of that case, you will see that they caution courts about even that exercise, that exercise must be done carefully without assuming jurisdiction where none exists. The power. Now, this is the second time I hear this submission generally, that where there is a lacuna, one is empowered. Where there is an exclusion, because I'm not mentioned that I can't do covert work. I'm not specifically mentioned in the Strategic Intelligence Act. Only the state security is mentioned. I am not excluded because they don't say I'm excluded. But the exclusion is found in who is empowered to do something. That's how I think, and how I think the legality is founded, is what does the statute permit, provides for. That is how a power is established. So it's an inherent exclusion. And our assumption that it was excluded because those who drafted it were being unfair, were not committed to truth or fairness, is an assumption that we shouldn't make. And so we also suggest this, not because the respondent or any of our witnesses fear anything, but we make this suggestion to suggest that the basic point made here, that the exclusion means you are empowered to. We suggest that the court, the tribunal should steer clear of breaching that legal position, that statutory position in its search for fairness. Because in its search for fairness, it must also realize that it's fairness to both sides. I've made this point several times. And I think the prejudice about which we are told that may happen, if any, is mitigated by the suggestion, and I don't think anybody would really reject the suggestion that yes, the evidence leader and the complainant's legal representatives must work hand in hand to field questions that they think the evidence leader has excluded. Lastly, the complainant's legal representatives were aware of this right at the beginning. In fact, I'm going to take you to what my learned friend says on the 13th of January 2025. And I'm not suggesting anything. I'm just saying that they were aware of this position. Page 36. And my learned friend at line 10 says, I will not be leading witnesses. Full stop. That's one line. And it says, I will not be cross-examining witnesses. This is the opportunity that I have to address this tribunal, and I thank you for that. So I'm saying the awareness about the legal position was there right at the beginning. And so we suggest that to subject witnesses to two cross-examiners in breach of a clear non-existence of the power would be unfair. Yes, would be an attempt at truth-finding, but would both be unfair and unlawful. And we propose, therefore, that this can be mitigated and time can be saved if there is permission for the legal representatives to collaborate with the evidence leader to field questions, whatever question they think should be fielded. Those are our submissions, Chair.
Yes, Advocate.
Just two things, Chair. The first is just to distinguish between the well-known rule that two people on the same team are not entitled to cross-examine a witness from a situation in which multiple teams of counsel are separately entitled to cross-examine, and that we see routinely in our courts. So that's two different situations, and here we have regarded ourselves as a separate team. But I take the chair's point, which is different to what Advocate Sekane is talking about, which is really that the complainant was only cross-examined once and the respondents twice. I accept that point. I can't contradict you. That is true. That would happen. The second point is to say this, is that I'm quoted by Advocate Sekane from the first day of these proceedings. That quote is taken a little bit out of context in the sense that that was absolutely my position. It's always been my position. The rules are clear that we don't have a right to participate. And that's why I said I'm not leading evidence and I'm not cross-examining. But if you read the full engagement on that day, which we refer to in our letter that responds to the respondent's letter raising this issue in the first place, we put the whole section of that transcript in, which is to say, after I raised that, the chair intervened and said, it's your decision as the chair to decide who speaks and who does not. And that was an exercise of that discretion, and then you clarified that we'd be entitled to questions. So I just want to place that context on record, that it's not that I'm changing my position. I've never changed my position. The position has always been that we understand this would be an exercise of your discretion, and that is why we seek your permission to do so. Other than that, Chair, I stand by submissions. This is a decision the panel will take considering all of the factors we've discussed.
Let us adjourn for 15 minutes. We'll come back and give a ruling at quarter to 3. Thank you. Let us, for the record, this is a ruling by the tribunal on the application brought by the complainant's legal representative for the right to cross-examine the respondent and all the witnesses testify on behalf of the respondent. After looking at the Act and the rules, we are of the view that such a right should not be granted. And we say so for certain considerations. Indicating that we strove in the discussion of our exercise in conducting our procedure, we strove to achieve fairness as far as possible. And this would include, one, the fact that we allowed legal representation for the complainant, albeit within limits. Secondly, we allowed complainant's legal representatives to put questions to witnesses that had been called by the evidence leader. We have also taken into account the fact that as and when the process of adducing evidence for the respondent and his witnesses, the complainant's legal representatives will be given the time to consult, if need be, with the lead of evidence in order to indicate to the lead of evidence as to which areas they would like them to be traversed through cross-examination by the leader of evidence. As I say, should the need arise in respect of the respondent or any other witness to testify on the respondent, such a privilege and opportunity will be given. Furthermore, we have decided to allow the complainant's legal representative to submit written argument when the time comes in support, if they so wish, of the complainant's case. Also troubling is the fact that if the wish were to be granted, whereas the complainant would be cross-examined only once, the respondent and every single witness the respondent would have called would have to be cross-examined twice. And one wonders what fairness is there in such a situation. But anyway, that's one of the considerations we took into account. That said, in due course, we are going to give full reasons for this decision, so that it becomes fully understood why we come to this decision that we do. The ruling is therefore that the legal representatives of the complainant would not be entitled to cross-examine the respondent, and witnesses called at the instance of the respondent. If they so wish, they would, as it were, have to do that through and in consultation with the leader of evidence. That is the ruling. Advocate Skippers, I was waiting for as the court pleases, but
As the tribunal.
I've long left the court. So, Advocate Skippers.
Yes, Chair. I think it's now for the case for the respondent.
Oh yes, Mr. Sikakane.
Thank you, Chair. Chair, so much has crystallized in this case, and so I'm not going to waste time about traversing what this case is about and all the elements. But I want to start with this, because there's a lot of mischaracterization that can happen in a case like this. And I'm going to start with what it's not about. And then I'll get to what it is about. This case is not about and has never been about the following: whether the complainant endured inappropriate comments and gestures regarding her physical appearance. Indeed, neither in her complaint nor in this tribunal did the complainant make comment about those claims. The second point is that this case is not about whether the conduct of the Judge President contravened or breached Article 5.1 of the Judicial Code of Conduct, which says as follows: a judge must always, and not only in the discharge of official duties, act honorably and in any manner befitting judicial office. It's not the case that was in the notice for him to meet. Second, that all activities of a judge must be compatible with the status of a judicial officer. I'm not saying these are unimportant. I'm saying the case that he came to meet was not this one. And what was the case to meet? And these have no competent verdicts. What I'm about to read, which is the case that was presented for him to meet. And it's found in Form 2, which is the notice in terms of Rule 4 of the Rules Regulating Procedures. And the note that notified the respondent about the case that he had come to meet said, and I quote, "It is alleged that the facts set out in Annex A to this notice constitute a complaint of gross misconduct against you," close quote. And Annex A made reference to the complaint by the complainant, Ms. Mengo, which is dated 12th January 2023, I'm sorry. And the notice further notified the respondent that, quote, "A concise summary of the evidence and any other information which substantiates the complaint against you is set out in Annex B." And what does Annex B state? It states as follows. The heading there is concise summary of evidence. It is alleged that between June 2021 and November 2022, you sexually harassed the complainant, Ms. Andiswa Mengo, by A, sending her on WhatsApp messaging service unwelcomed, unwanted messages of a sexual nature, as well as crude pictures. And lastly, B, behaving indecently towards her in your office at the High Court in Umtata, close quote. The contents of Annex B, of course, mirror the JCC's summation of Ms. Mengo's complaint. And at paragraph 1, the JCC summarized the case made by Ms. Mengo in her complaint in the following terms. And I quote, "She, Ms. Mengo, alleged that between June 2021 and November 2022, the Judge President sexually harassed her by A, sending her on WhatsApp messaging service unwelcome, unwanted messages of a sexual nature and crude pictures, B, behaving indecently towards her in his office." Similarly, I mean, the similarity of the words in the JCC's summation and the terms of Annexure B is stuck for a reason, of course. That is hardly surprising. After a thorough examination of the parties' assertions, that Ms. Mengo's complaint and the respondent's response, the JCC identified the issues which it was called upon to determine in the following way, quote, "The inquiry at this stage is whether the Judge President's conduct prima facie constitutes sexual harassment." This is at paragraph 21 of this. And it went further to make itself clearer at paragraph 24. The JCC then identified the issue before it as follows, quote, "As a prelude to considering the complaint before us, it is common cause that the Judge President made sexual advances to Ms. A.M. I think it's Ms. Mengo. The question is whether those were unwanted, and if so, whether the JP knew or ought to reasonably have known that they were unwanted. Of course, the narrow campus of the inquiry is much clearer and perspicuous by the ratio of the decision to recommend the referral to this tribunal, which was made at paragraph 27 by the JCC. It says, "The contours of sexual harassment are complex, and in this case, they would be best resolved in an investigation where the parties' versions would be tested through cross-examination and possibly expert evidence. For example, this committee is not equipped to determine whether certain pictures were downloaded from the internet, as alleged by the President, or sent from the Judge President, as alleged by Ms. A.M. The most appropriate conclusion is to refer all those aspects, including the contents of Acting Deputy Judge President's affidavit, for further investigation." Now, this, of course, this summation accords with what we would call a liberal reading of Ms. Mengo's complaint as set out in Annexure A. Therefore, this is the case that is to be determined, and this is the case that the respondent was to meet, so that it's not mischaracterized. And of course, my parting shot in this is that while there are issues that are disputed, and there are facts that are disputed, it will be revealed through his own testimony, the conversations that he had. And those will become clearer because they are uncontested. As he testifies, he will demonstrate to the tribunal which things in the entire accusations did not happen, which pictures are alleged to have been sent by him, but he didn't. The rest of the evidence is factual and has been led, and experts have appeared before this tribunal. And to make this entire case and to give the facts that support his version of events, the following witnesses will be called. The first one, and I would like to give the tribunal the entire list once and for all. And in fact, I'm giving it in the order in which they will come. The first one will be Ms. Zinhle Nqayi. The second one will be Ms. Unathi Sokoni. The third one will be Dr. Mello. And the last one will be the Judge President himself, the respondent. And at this point, Chair, I would like to hand over to Mr. Madonsela, who will deal with the first three witnesses that I've mentioned, and I'll hand over to him as we start our evidence. Thank you, Chair.
Thank you, Chair. Through you, Chair, may I have leave to call to evidence Mrs. Zinhle Nqayi.
your full names, please.
Sicela amagama akho onke nefani.
nguzinhle Nqayi.
Zinhle Nqayi.
Do you have any objection against taking an oath?
Ingabe unayo ingxaki nokufunga?
Ayi.
No objection, Chair.
Will you raise your hand to say that the evidence you are about to give will be nothing else but the truth? Raise your right hand and say, so help me God.
Uyawuphakamisa isandla sakho ke ukubonakalisa into ba uyavuma ukuba ubungqina bakho zabunikezela buyaba inyaniso yonke, inyaniso yodwa, ulanduleke ngamazwi athi ndincede Thixo.
Ndincede Thixo ndithethe inyaniso.
So help me God.
Yes. Mr. Madonsela.
Thank you, Chair. Mrs. Ngai, can you please tell this tribunal where did you work between the period 2017 to April 2025?
Kawuchazele ke lengqithela into kokuba ubusebenza phi phakathi komnyaka ka2017 no April ku2025.
From March, okay, usukela ngo-March ka-2017 to andiqinisekanga phakathi kodwa ku-2020 bendisebenza eBisho njenge-stenographer.
Okay. Between the period of March 2017, I'm not 100% certain of the exact dates, but up to 2020, that's the year,
eBisho High Court.
I worked at the Bisho High Court as a stenographer.
Ku-2020 njalo ndasebenza njengonobhala kaJudge President Mbenenge.
During 2020, I worked as the secretary for the Judge President Mbenenge.
Mrs. Nkai, if you can just speak louder so that we can all hear you, so that if she misinterprets or interprets you wrongly, we should correct her. But we can only do that if we hear you. Right, please.
Phakamisene benchilo mos. Funa uyiva kuwe uba ndiyayimosha bazandilungisa.
Okay.
Because we'll do che.
Uyokuma ke nge-30 ka-April 2025.
Ukusuka ku2020 usebenzele uJP ukuyokuma kuApril
2025.
From the year 2020, I worked for the JP Mbenenge up to April 2025.
The focus of my questioning to you today will be during the period when you act as the Judge President Secretary.
Apho ndizawuthi ndinqale khona ke ngokuphathelene nemibuzo yam kuwe ndifuna sijongane nela xesha ubusebenza njengonobhala kaJudge President.
And I would like you to
Okay.
address yourself to two topics.
Two topics.
Yeah.
Zizihloko zibini ke endifuna ukuba sijongane nazo. Okay.
The first topic is in relation to an incident that allegedly took place on the 28th of May 2021 at Grahamstown High Court.
Eyokuqala ke ndifuna siyinike ingqwalasela okanye indima yesihloko sisehlo esenzeka ngomhla we28 kuMeyi ngomnyaka ka2020. Is it 2021, Council?
Yes.
Umnyaka ka2021 ingakumbi khona phaya eGrahamstown High Court.
Chair, with your permission, may I please direct you the references of the pages of documents which have been submitted before this tribunal dealing with that incident. They are to be found in volume 1, Tribunal volume 1 at page 4, it's paragraph 5 and 6, that is the complainant's complaint. And they are also dealt with at the same volume, page 165 by the respondent at page 165, paragraph 40. It's that incident about the Ms. Mengo allegedly entering the JP's office and seeing the JP hugging the court manager, to summarize it.
Okay.
I'm just referring to it just for purposes of knowing where the documents, the story is.
We are looking at what is described as Exhibit 5, but then you referred us to a page. What page did you refer us to?
I said, Chair, this incident that I want to deal with is to be found in volume 1, page 4, that is the complainant's complaint, at paragraph 5 and 6. And it is dealt with by the respondent in his response to the complaint at page 165 in paragraph 40. Just for reference, Chair, I do not propose that we go there.
Oh, okay.
It's just for the purposes of the tribunal knowing that the incident I'm talking about is contained in those documents.
Right. Okay.
Counsel, we do not have anything in front of us. Just
Yes, sir, no, you don't have to have anything. It's also
right.
for the benefit of the tribunal.
All right.
Ms. Ngai, this incident, alleged incident, is said to have taken place at the Judge President's chambers in Grahamstown High Court. The complainant, Ms. Mengo, says at some point on that day, she went to the JP, the respondent, to complain about the court manager. She left, and then she came back. When she came back, she peeped through the JP's office and saw the JP hugging the court manager.
Isehloke esi sithetha ngaso sangalomhla we-28 kuMeyi ku-2021 kutyholwa ngelokokuba lowo ke ubeke isikhalazo onguMiss Mengo uthi ngalomhla wayephaya kanye erhini kwiofisi le kaJP apho wathi xedlula wanento ekrobayo wabona pha ngaphakathi into kokuba uJP wanga court manager. Silapho apho sikhoyo.
The JP says that incident did not the hugging incident did not take place.
Uthi ke yena uJP ukuzithethelela ayikhange yenzeke kwaleyo kwangana okanye yehug.
And I ask you to clarify, according to your knowledge, whether do you remember what happened on that date?
Ndinesicelo ke sento kokuba nawe ukhe usityhilele okanye uzama ukuyicacisa ukuba usayikhumbula uba ingabi khona into ekumila kunjalo eyathi yenzeka ngalamini.
Ngalamini kufika uMiss Mengo eofisini kaJP.
On the date in question, Miss Mengo came to the JP's office.
Asondele kum acele ubona uJP.
She approached me and requested to see the JP.
Ndinqonqozile ofisini kuJP ndamxelela uba unondwendwe olunguMiss Mengo olucela ukumbona.
I therefore proceeded to knock on the JP's door and informed him that he has a visitor by the name of Miss Mengo, who is requesting to see him.
Uye wathi mandimngenise.
He then told me to let her in.
Ndimngenisile ofisini kaJP, ndavala ucango, ndabuyela edeskini yam, ndaqhubeka nomsebenzi.
I indeed proceeded to let her in the JP's office. I closed the door, went back to my desk to continue with my duties. Uba.
Uphumile uMiss Mengo eofisini kaJP,
Miss Mengo then came out of the JP's office,
uJP wandibiza,
and the JP called me in.
wacela ndimbizele ucourt manager, uMiss Tambodala.
He then requested me to call the court manager, whose name is Miss Tambodala,
Ndimfonele uMiss Tambodala andamfumana efonini, ndehla ngenyawo ofisi yakhe isezantsi kunathi.
I called Miss Tambodala telephonically, and I was unsuccessful. I then decided to walk to her office, which is an office placed downstairs in the building.
Ndifike xa ephuma ku-office opposite naye, ndamxelela uba uyacelwa nguJP.
I found her coming out of an office that is opposite her office, and I informed her that the JP is requesting to see her.
Ndiye ndanyuka kuqala ke kunaye, wabe elandela emveni kwam, kodwa ndafika kuqala kunaye ofisini.
I left ahead of her. I went up. She followed. I therefore arrived first in the office.
Ndimxelele ke uJP ba uMiss Tambodala usemveni kwam, uyeza.
I then informed the JP that Miss Tambodala is right behind me. She's coming.
Eneneni ufikile, ndamxelela uJP uMiss Tambodala sefikile ofisini, wacela ndimngenise. Ndamngenisa, ndavala ucango.
Indeed, she arrived. I informed the JP that Miss Tambodala has arrived. I had let her in, and I closed the door and proceeded.
Ndabuyela etafuleni yam, ndaqhubeka nomsebenzi.
I went back to my table and proceeded with my duties.
Uphumile uMiss Tambodala, ekuphumeni kwakhe uJP undicelile ndibize uregistrar wenguMiss Shenxane ngelo xesha.
After Miss Tambodala had left or came out of the JP's office, the JP then came out and he requested me to call the then registrar,
Miss Shenxane.
Miss Shenxane,
Ndimfonele ke yena, ndamfumana efonini, wangena eofisini, ndamxelela uJP ukhona uMiss Shenxane, wathi mandimngenise, ndamngenisa.
I called her. Fortunately, I found her telephonically. I informed her that the JP would like to see her. Indeed, she came. I informed the JP of her arrival. I had let her in the JP's office. After informing the JP that she has arrived.
Uphumile naye uMiss Shenxane ngexesha lakhe, kwabe kuzawungena i-meeting eyizawuba khona with i-staff se-case flow.
Ms. Shengane also came out after she had finished, and there was a meeting that was scheduled to sit with the staff for case flow.
Siqhubekile nomsebenzi wemini kwafikelela ixesha loba sibuyele East London sabuyela khona.
We continued with the daily duties until we finished. Then came a time where we had to now return back to East London, and that's where we went.
Nantso ke into endiyikhumbulayo eyenzeka ngala mini.
That is what I can recall that took place on the date in question.
So in light of that explanation, does Ms. Mengo's allegation that she came back to later stage, peeped to the JP's office and saw the JP hugging the court manager, does that allegation have any substance or truth in it, according to you?
Phezu kwale ngcaciso ke ngokugqiba kusinika yona ngokukhumbula kwakho kwenzekayo, ingaba esi sityholo aye wasibeka uMiss Mengo sento kokuba waye wayinto ekrobayo kule ofisi ka-JP wafika besangana, ingaba ingayinto eyinyani ngokukhumbula kwakho?
Ngokukhumbula kwami ingaba yinto engeyonyani.
According to my recollection, it could be something that is not true.
Did it happen in your presence?
Yenzekile phambi kwakho wazibonela nawe?
Andibonanga isenzeka ungena kwakhe ayoqoba eofisini ka-JP ngoba mna ndifake u-court manager ndabuyela edeskeni yam efacane nomnyango straight ka-JP.
I did not see it happening, especially when she went into the JP's office. I just let her in, and the door is actually directly facing
Tafile yam
tafile yakho. It's directly facing my table where I'll be seated.
After Ms. Mengo left, were you always at your desk?
Emveni koba uMiss Mengo lo eye waphuma wahamba, when busoloko ngalo lonke ixesha upha etafuleni yakho?
Ndiphume only emveni kwakhe ngela xesha u-JP athi mandiyobiza u-court manager.
I only left my table after her. This is now when the JP had requested me to go and call on the court manager.
And when the court manager came and left, did you at any stage leave your office?
Ekufikeni kwakhe ke ngoku u-court manager uke wanethuba wena apho oye wayishiya i-office le yakho waphuma wangabikho?
Not ngela xesha ase-ofisini ka-JP.
Not during the time that she was in the JP's office, no.
After she had left, after Ms. Mengo had left the JP's office, did you at any stage leave your office?
Emveni koba uMiss Mengo eye waphuma yena apha e-ofisini wemka, wena uke waphuma nawe wayishiya i-office?
Yes.
Yes.
After the court manager had left the office of the JP, were you always at your desk until you called the other registrar, Ms. Shikane?
Emveni koba u-court manager ephumile wahamba, wena uke wayishiya i-office uyokulanda ke uMiss Shengane lo kuye kwathiwa mfowunele?
No.
No, I did not leave.
So just to sum up on this topic, all the time that Ms. Mengo was in the JP's office, you were at your desk?
Ukuyiqukumbela ke ngakumbi kule ndawo, ngalo lonke lixesha uMiss Mengo elapha e-ofisini ka-JP, wena bulapha etafuleni yakho?
Kunjalo.
That is correct.
Moving to the next topic, the second topic I'd like you to address.
Sizawungena ke ngoku kwisihloko sesibini ne endifuna sithethe ngaso.
This relates to an incident of the 14th of November, 2021.
Lena ke yona into yenzeke ngomhla we-14 kuNovember ku-2021.
At Umtata High Court.
Khona phaya eMthatha eHigh Court, ne?
Chair, can I ask the panel to have regard to Annexure 5 or Exhibit 5? Chair, may I please put in context this exhibit and advise you what agreement we have had with the evidence leader and the complainant's legal representatives on this topic. You'll recall, Chair, that at some point during the evidence of Mr. Naidu and Mr. Chete, there was a footage which was viewed by the tribunal. And this note is a summary of what was observed in the footage of the 14th of November in Umtata High Court. We have agreed, subject to your agreement, that we should dispense with the need of viewing the footage in the presence of this witness in order to curtail time. But this witness has viewed the footage on her own. So we propose, Chair, that we deal with the I don't know whether that meets your requirements or acceptance.
You agreed with?
With the evidence leader as well as the complainant's legal representatives, that it won't be necessary to view the footage.
Yeah, no, that's fine. You people know your respective cases perhaps a lot better than us. Let us see how it will work out.
Now, Ms. Ngai, on the 14th of November, you were at Umtata High Court, not so?
Ngomhla we-14 kwinyanga kaNovemba kunyaka ka-2021 wawuphaya eMthatha enkundleni ephakamileyo kunjalo?
Kunjalo.
That is correct.
And it is common cause that at Umtata High Court there is a CCTV that is placed in the corridors of the High Court, not so?
Into eyazekayo ke ngamanye amazwi ayiphikiswa yokuba phaya enkundleni ephakamileyo yaseMthatha kukhona ii-cameras ezikhoyo apha ezirhangini kunjalo?
Kunjalo.
That is correct.
The CC footage of the 14th of November depicting the corridor between Chamber 1 and the corner of the JP's office has been put before this tribunal.
Apha ke kule CCTV iyasibonisa ukuba iofisi leka JP engunumber 1 apha ikhoyo okanye masithi ioffice engunumber 1 apho ikhoyo nekona apho ioffice ka JP ikhoyo. Siyayibona apha kwi CCTV.
Kunjalo.
That's correct.
You viewed that footage, did you not?
Uye wayijonga lento yale footage and it?
Kunjalo.
That's correct.
And you have had regard to Exhibit 5, have you not?
wanako nokukunyondla ukubona kwesi siboniso ke singu exhibit 5 kunjalo.
Kunjalo.
That's correct.
Did you compare what you saw on the footage with the notes which have been made about what the footage depicts?
Ingaba uye wathelekisa kwimbalelwano le nento elapha kwi CCTV footage uyithelekisa uyibona ba ingaba ziyangqinelana na?
Ewe kunjalo.
Yes, that's correct.
Are they the same? Does exhibit 5 correctly depict what is shown on the footage?
Ingabu exhibit 5 ke lo obhaliweyo nale uyibukele kwi CCTV ziyangqinelana?
Ewe kunjalo.
Yes, that's correct.
Now, what time did you arrive at Umtata High Court on the 14th of November?
Ufike ngabani ixesha phaya eMthatha High Court nge-14 zikaNovember?
Ndingathi mhlambi ngo-8.
I could say maybe around 8.
And what time did you leave?
Waze wahamba ngabani ixesha?
Ndihambe phambi koba kubethu 5.
I left before 5 o'clock.
Now, was the JP present at the High Court on that date?
Ingaba ngalo mhla sithetha ngawo uJP wayekhona phaya eHigh Court?
Ewe.
Yes.
Can you, in
Sorry,
your,
Mr. Madonse. You asked her what time did she leave. She said, I left before 5 o'clock. But that doesn't still tell us when she left. You see.
I'll come back to that. I'll come back to that.
Oh, do you really have to come back to that?
Yes, there is a little bit of precision that is needed for that purpose.
Okay.
Chair, can I just say, when I come back on that topic, I will deal with what appears at page 171.
All right.
Is the register.
Okay, thank you.
So, with the permission, sir, may I just deal with the other issues that I was pursuing?
You have always had that permission.
Now, was the JP present at the High Court on that day?
Ingaba ngalo mhla sithetha ngawo uJP wayekhona phaya eHigh Court?
Ewe kunjalo.
Yes, that is correct.
In Exhibit 5, it is recorded. There are 2 recordings dealing with that day. The one appears in the second page under footage 1 with the topic morning of 14 November 2022. Can you see that?
Apha ke kweli phepha lesibini baphawulile pha phezulu bachaza ba ngentsasa ye-14 kaNovember bayachaza kuba kwenzeke ntoni. Uyayibona ne?
Ewe.
Yes.
Now, before I deal with that, with the footage and the certain aspects of the footage depicting the movements in that corridor, can you just confirm the layout of the office, your office, in relation to that of the Judge President?
Phambi kokuba ndingene nzulu kwinto yayisenzeka intshukumo yayisenzeka apha kule rhanga sithetha ngayo kanye kule passage khasinika umfanekiso ngqondweni malunga neyakho ioffice ime njani nokuthelekiswa nale kaJP.
Ngokwepassage i-office ka-JP ibambe ikona.
According to the passage, the JP's office is in the corner
Eyam ilapha ecaleni kwale yakhe.
and my office is right next to his.
Njembe ibambe ikona nje office yakhe apha phakathi kule yami office kukho umnyango oya straight kula office yakhe.
As his office is in the corner and in relation to where my office is, which is right next to his, inside my office, there's a door that leads straight directly into the JP's office.
And if people if anyone wants to come to see the JP, how does it enter into JP's office?
Uba ngabana kukho umntu okanye abantu abafuna uzokubona uJP, bazawungena njani ukwazi uba bakwazi ukumbona?
Umntu oya eofisini kaJP uqala eofisini yam kum achaze uba ucela ubona uJP okanye uzobona uJP.
Whoever comes with the intention to see the JP will have to start in my office and make their request known that they are there to see the JP, and they will tell me as to who they are.
Now, we know from the...
Mr. Madonsela, you'll tell us when it is a convenient point to break until tomorrow, personally.
Yeah, I'm going to spend time on this topic. Are we supposed to leave at 3:30 or 4 o'clock?
Past-
3:30. I thought we were going until 4 o'clock, sorry.
No,
It is 3:30 now. We can adjourn now and resume tomorrow morning. With
yes,
your
if
permission.
yes, if it is convenient for you.
Convenient.
Yes. We'll adjourn until tomorrow, 9:30. Tell the witness